Everyone, I'm Vi Lyles, and I am calling the Charlotte City Council Strategic Planning Meeting to order. Today is Monday, August the 2nd. I hope everybody has had a great vacation. I was out, so I don't know what happened in the world. I'll look at all the media stories later, but I turned on the TV and I saw Joe Bruno anchoring something. Congratulations on your new positioning. Thank you. Today, we're going to start our meeting. Our meeting is being held virtually within the state orders that we've been talking about for over, I think, 15 or so months. And we wanted to do a few things, just housekeeping before we start. But we're going to begin with our introductions. As I said, I'm Vi Lyles, and I serve as mayor. And then we'll go ahead and introduce the folks that are joining us inside of our building, and then we'll go to those that are attending virtually. So we'll go with the council members first, and then follow with the staff. So, Ms.
Good evening, Renee Johnson, District 4.
Malcolm Graham, District 2.
Greg Phipps, at large.
Tarek Bakari, District 6.
All right, any other council members in attendance in the building? All right, so virtually, we'll start with our council members attending virtually.
Braxton Winston at large.
Larkin Eggleston, District 1.
Troy Watlington, District 3.
All right.
Ed Driggs, District 7.
All right, thank you very much. We have Councilmember Dimple Ajmir is not going to be joining us virtually. She will be absent for this meeting. She sends her regrets. And we may have Mayor Pro Tem Iselt join us. She's at a training session, and I think her class isn't over yet, but she may be joining us later in the meeting. So with that, I have not heard from Mr. Newton. We have not heard from Mr. Newton. So with that, we'll go ahead and begin. I just wanted to mention today, the City of Charlotte is following the recommendations from the Center of Disease Control and Prevention, all of us now know as CDC, and we're recommending all employees wear masks regardless of vaccination status inside of city buildings. The Government Center remains closed to the public except for council action review and business meetings, strategy sessions, and zoning meetings, and public meetings that are being held by the Mecklenburg County Board of Commissioners in the building, as well as the Charlotte Mecklenburg School Board. During our city council meetings, you can see from the way that the meeting is set up, we are social distancing for those who choose to attend the meeting in person, and we have virtual options for those that choose to be virtual. I just want to say to this community, the best protection against COVID-19, as well as the Delta virus, is that the vaccination. And we strongly encourage everyone in our community, our city, to get fully vaccinated. And to schedule a vaccine appointment or find a walk-in clinic, visit vaccines.gov, and you will be helped to be able to do this. Today, we do have the media attending our meeting, as well as several citizens, and I appreciate those that are in the chamber, as well as those that are joining us in a socially distanced way. Because this is a strategy session, we really are glad that you're here to listen. We will be discussing a proposal, and then we will talk about that at the end of the next steps at the end of the council discussion. I also wanted to make a note of something that's really important tomorrow. You know, Charlotte, as well as other cities and communities across this country, celebrates National Night Out. The reason that we have National Night Out is that we begin to try to look at a bond between our police officers and the people who live in many of our neighborhoods, in all of our neighborhoods. And when you think about the past 18 months, we've made tremendous strides. We've done a lot of hard work to make our community safer. Community policing is still important, and community engagement with police is a major priority. The work that the City Council has done and funded is really important to the safety of our city. And we know that it's a partnership. With our communities, our neighborhoods, we can be productive and successful. National Night Out is a part of that partnership. And tomorrow we have the opportunity to make it stronger. This year we have more than 70 registered National Night Out events in Charlotte. And I've been told that CMPD officers will be at every single one of them. So we want to thank those that serve. We want to thank those that support this effort. I know that I'll be around town as making it as much as often as I can to as many events as I can. And I know that you'll see other members of the City Council out there also. So we're delighted to be invited and glad to be in attendance at your event. And I hope that everyone will observe National Night Out for the opportunities it presents for all of us. So with that, we have one item on our agenda, but I wanted to have an introduction of the staff as well. So I'm going to start with the city manager so that you know who's in the room. I failed to do that right after the council introduction. So, Mr.
Thank you, Mayor. Marcus Jones, City Manager.
Stephanie Kelly, City Clerk.
Lena James, Deputy City Attorney.
Donata Jackson, Office of Constituent Services.
Kay Cunningham, Mayor's Office.
Also in the room that's behind us, we will have other staff members who are available for questions by the council or as needed from the city manager. They will join us as needed. So we have one item on our agenda tonight. It is the proposed and recommended non-discrimination ordinance discussion. You know, we set up these sessions so that council has a chance to talk through an item in an informal discussion. I don't know if there's anything informal about a discussion with the city council as we meet, but to have this discussion so that when we look at this item, which is planned to be on our agenda for August the 9th, that we have a full and deep understanding of what it is and what we're intending to do. Questions are asked and answered. So I want to welcome Councilmember Newton to joining us tonight, and we are going to start with our city attorney, who is going to make an introduction to the recommended ordinance.
Thank you, Madam Mayor, members of council. Again, I'm Patrick Baker, the city attorney, and I am here to discuss the proposed revisions to the non-discrimination ordinance. First, let me thank each of you. I think I've had multiple conversations with you over several months to discuss this particular ordinance, getting feedback from you, your constituents as well. It has been an interesting process, and I hope that what I'm presenting to you is something close that I can at least deliver to you, so you can then make further tweaks and suggestions back to me that I will make sure are codified in the proposal for your consideration on the 9th of August. So we'll go ahead and get started. And I've just got a table of contents here in terms of what I'm going to try to discuss with you, major changes since 2016. We'll go over a brief history of how we got here and then get right into the proposed ordinance amendments. Major changes since 2016. A couple things that I want to bring to your attention just right off the bat. HB 142, which you'll recall that was enacted back in, I believe it was 2017, that prohibited local governments from enacting non-discrimination ordinances based in part on public accommodations and regulating private employment practices. That came with a sunset provision that expired on December the 1st, 2020. So that prohibition no longer exists. There have been a number of municipalities around the state that have enacted local non-discrimination ordinances in the areas of public housing and regulating private employment, and that is part and parcel of what we're being asked to discuss. I do want to also make sure it's very clear to the council and the community that the preemption of the regulation of access to multiple occupancy restrooms is still in effect, and nothing nothing in what I'm about to discuss with you will address that. We are not recommending, and these ordinance revisions don't defy that preemption that still exists from the General Assembly going forward. Second matter I want to bring to your attention since 2016 is the Bostock versus Clayton County case. This was a Supreme Court case that was decided in June of 2020. As you see there in a 6-3 decision, the majority in an opinion written by Justice Neil Gorsuch determined that discrimination on the basis of sexual orientation or gender identity was necessarily discrimination on the basis of sex as prohibited under federal law. So we take out of the Bostock case that discrimination for sexual orientation, gender identity, gender expression is part and parcel of sex discrimination and is a violation of Title VII of the civil rights laws. There's some language there that just makes that point very clear from Justice Gorsuch. He also acknowledged, as is typical in major Supreme Court cases, that the opinion would raise questions on its application in fact patterns that were not before the court. In fact, the court said, it mentioned sex-segregated bathrooms, locker rooms, and dress codes will prove unsustainable. They say that would happen, but that wasn't before the court. And what typically happens in these cases is that subsequent cases come up through the courts as well to expound upon the main case coming out of, in this case, Bostock. So a number of cases will work their way up through the Federal Circuit Court of Appeals and maybe back to the Supreme Court to further explain what Bostock means, what it doesn't mean, and that's typical as we go forward. But there'll be a lot of fact patterns that folks will ask you about, and the way that this comes out in terms of case law is that over the course of time, the cases will either expand or retract some of the findings in Bostock. But right now, that's the law of the land as we speak. I've lost my, can I do a page up? Down. Down. Not working. Okay, looks like I'm back up. All right, for the areas that have been regulated by the city ordinances, they include public accommodations, passenger vehicle for hire, and commercial non-discrimination policies. Those are the ordinances that are on the books right now, and we are also proposing a new area of regulation, and that's an employment for employers that have fewer than 15 employees going forward. The classes that were previously covered included race, color, gender, religion, sex, national origin, ethnicity, age, and disability. Proposed new classes, and I use that word a little cautiously because the question ultimately is whether it's an actual new class or is it simply an understanding that a particular class will include an additional group of individuals. But with that as a caveat, we're talking about sexual orientation, gender identity, gender expression, and those are included under sex discrimination. Pregnancy, which is also a part of sex discrimination, veteran status, familial status, and natural hairstyle, which has been considered, and I've got a page on the Crown Act, has been considered to be falling under race or national origin discrimination. And here I've listed the categories out there for you so you can see the differences, what we had on the left and what we're adding on the right in the proposed ordinance revisions. Federal law, the source of authority that we have from there, Civil Rights Act of 1964 and 1968 has governed race, color, religion, and national origin discrimination in public accommodations, and employment, race, color, religion, sex, national origin. Disability was added in 1990 and age was added in 1967. There was no specific law recognizing protections for sexual orientation, gender identity, gender expression until the Bostock case, which read into sex discrimination protections for sexual orientation, gender identity, and gender expression. State law, there is state law addressing public accommodations, particularly Persons with Disabilities Act. There's also authority under state law for passenger vehicle for hire and procurement ordinances. And there is a state EEO law, equal employment law, that addresses employers above 15 or more employees, consistent with federal law, also dealing with race, color, religion, sex, national origin, pregnancy, disability, veteran status, and age. City code provisions. In 1968, the City of Charlotte adopted a code provision in public accommodations protecting discrimination on the grounds of race, color, religion, national origin. 1972, the term sex was added to your public accommodation discrimination ordinance, and the enforcement of that particular ordinance is through the Community Relations Committee. In 1968, also, the Community Relations Committee was established by ordinance, and members are jointly appointed by the City Council and County Commissioners. They have duties making recommendation for the elimination or reduction of discrimination in housing and public accommodations, and I will speak to housing in a few moments. And they also have a conciliation process where if there's a finding of discrimination, there's an opportunity for the CRC to offer conciliation services to both the complaining party and the respondent to address any issues of discrimination going forward. Passenger vehicle for hire currently prohibits companies and drivers from discriminating on the basis of race, color, religion, sex, or national origin. The enforcement there is through the PVH board and CMPD. There are access to potential civil penalties and revocation of operating certificates and permits, and including but not limited to equitable remedies, injunctive relief pursued through the courts. We also have a commercial non-discrimination policy. This is the ability to not have to, for the city to not engage with vendors who engage in discriminatory practices. You see there, city contractors may not discriminate against vendors, suppliers, subcontractors, or commercial customers on the basis of race, gender, religion, national origin, ethnicity, age, or disability. The enforcement there is a potential rescission, suspension, or termination of a current contract and disqualification for bidding on city contracts for up to 2 years. And let me stop there. Any questions about the history? And we're going to go ahead and dive right into the ordinance.
I believe I'll give you the time, Madam Clerk, that she did join at 5:15. Thank you. All right, are there any questions? I'm looking at the board, the virtual board. Is there any questions from anyone that's attending virtually? There are no questions on the history. Any other person in the room with a question on the history? All right, Mr. Baker, thank you.
All right, we'll move on. So this is what we have for you today for your consideration. We are creating a new, more inclusive term called protected class. So rather than listing all of the individual classes that are subject to a non-discrimination ordinance, we're defining protected class that will cut across all of the identified areas, and particularly passenger vehicle for hire and the commercial non-discrimination, public accommodations, and the new employment discrimination area. That will be a protected class. That will include race, color, gender, religion, national origin, ethnicity, age, and sex and disability. Those are in black. They're already protected classes. And we're adding familial status and including sexual orientation, gender identity, gender expression from Bostock in the definition of sex, and natural hairstyle, veteran status, and pregnancy. And as I said, natural hairstyle we consider to be a potential fact pattern for a race and or national origin discrimination. But I do have a specific slide on natural hairstyle that I'll discuss with you. We're adding sexual orientation, gender identity, and gender expression, familial status to the passenger vehicle for hire ordinance, the first three being part and parcel of sex discrimination that already exist in those ordinances, and adding new definitions to public accommodations ordinance that also addresses sex. And because we're handling it as one protected class, we were able to strike the references to sex in that particular accommodation. But I want to be very clear that sex discrimination, including discrimination based on sexual orientation, gender identity, and gender expression, will also be included in the protected class definition in public accommodations. Employment discrimination, again, will have that new protected class, but we're focused on less than 15 employees. This particular provision has brought up a lot of conversation. A number of the other communities in North Carolina have either, I believe Greensboro and Orange County have enacted employment discrimination ordinances that are only applicable to employers 15 and above. The other communities, including, I believe, Durham, Chapel Hill, Carborough, Apex, and I feel like there's at least one or two, Asheville, have made their employment discrimination ordinances applicable to all employers within their jurisdiction. Again, there's a floor at the EEO, federal, and the state law that addresses employers, actually defines employers as having 15 or more employees, and there is a gap for the most part at that below 15 level. I have recommended that we focus on the gap in large part because between the federal laws and the state laws, there is protection for the larger employers or the larger employees. Let me start that over again. The employers that have 15 or more employees, I believe there's certainly an adequate remedy at law at both federal and state law, but there isn't one for the smaller employers, and I believe that it makes more sense to focus in that particular gap area. I know that has, again, got a lot of conversation about why aren't we doing it for everyone, going all the way up and down the line. But I just believe that it is duplicative of the existing statutory framework that exists with employers 15 and above. Enabling authority. How can we do these particular ordinances? And obviously the ordinances on public accommodations and the commercial non-discrimination have already been on your books for a long time. As I mentioned, this new ordinance that's really the focus of this conversation, the employment ordinance, we believe is consistent and similar to our other non-discrimination ordinances. That is, we derive that power from the General Assembly through the enactment of 160A, 174, our general ordinance making power. You probably referred to it as the police power. And there you see quotes from that particular section. The city may by ordinance regulate acts, emissions, or conditions detrimental to the health, safety, or welfare of its citizens and the peace and dignity of the city. Second source of authority comes from 168 194. Again, this is from the General Assembly giving to local governments the ability to regulate and license business trades, et cetera. That's the power to regulate businesses. And a quote from that section or that statute, city may by ordinance, subject to the general law of the state, regulate and license occupations, businesses, trades, professions, and forms of amusement or entertainment. On occasion, the state will put out a preemption or enact a statute that preempts the local governments from getting into a particular area. I think firearms is a very good example of a specific statute that prohibits what would otherwise appear to be within the authority for a local government to delve into that particular area, but that has not occurred from the state government on the issue of the employment practices. In fact, as I said in HB 142 at the outset, the General Assembly was very clear in that no local government in the state may enact or amend an ordinance regulating private employment practices or regulating public accommodation, but then putting a sunset on that prohibition, which certainly suggests that we must have that authority to be able to do that, because there would be no reason to prohibit us from doing it if we didn't have that inherent authority. Those are the arguments. There's also some case law. I know that the Williams case, which I think some of you are familiar with, has been used in the past to suggest that through a local act, local governments are not allowed to enter into the area of employment practices. But what we're doing here is not pursuant to a local act. And by a local act, I mean a local act that has been prescribed by the General Assembly for a local government to proceed. This is not, we don't believe the Williams case is applicable here. And again, we're relying in large part on Bostock for the piece regarding sexual orientation, gender identity, and gender expression going forward. Crown Act. You all have heard, and maybe you didn't realize that the Crown Act is an acronym, stands for Creating a Respectful and Open World for Natural Hair. The Crown Act has been seen as legislation, and it's a term where it suggests that there's one Crown Act. There are many Crown Acts, but there's not a Crown Act that relates, that comes from the federal government, nor is there a Crown Act in the state of North Carolina, but a number of states have enacted a Crown Act that for the most part, and there have been different verbiage from state to state or locality to locality, but for the most part, it's essentially recognizing that natural hair discrimination can be part and parcel of either race discrimination or sex discrimination, or national origin discrimination, which are typically areas, protected class areas that are already covered. So it just makes the causal link between natural hair discrimination and race discrimination going forward. A number of communities that have enacted these non-identified going forward. There will be it will definitely be a fact as much natural hair, but we all have natural hair. That doesn't necessarily mean that you win your case. I think there are about 30 or 31 states that are actively considering Crown Act state acts in their either to a state Crown Act or a federal Crown Act. Enforcement, and this is really what I have here on this slide really focuses on the employment piece, but this is the enforcement mechanism that we have. Which provides that an employee may file a complaint with the Conciliation Division of the CRC. CRC then investigates the claims, and if they find reasonable cause to believe that there has been prohibited employment discrimination practiced by the employer, they will attempt to conciliate that situation between the employer and the employee. If the alleged violation is not able to be conciliated going forward, the complaint is then referred to the city attorney for appropriate action, and the city attorney would notify both the complainant and the respondent going forward. The term appropriate action has not been, this is part of the statute or the ordinance that exists right now, but appropriate action could be, and quite frankly, most likely would be a potential pursuit of an action in front of the civil courts on the grounds of either reaching for an injunction going forward or somehow to enjoin the prohibited activity from continuing. There is no private cause of action that's created in this process. And by private cause of action, I mean similar to the EEOC, where you file a complaint with the EEOC, that's at the federal level, and the EEOC can either take your case for you or issue you a notice of a right to sue letter. I don't believe we have the authority to issue right to sue letters, so the enforcement of our ordinances would be incumbent upon the city, and that would be the efforts to enforce in that particular area. Religious freedom exemptions. This have been a significant point of conversation as well. I have seen ordinances that list out basically case law developed exemptions that have developed over the course of time. What we've tried to do in this ordinance is to simply state that we intend in this ordinance as well. We're not trying to change the law for religious organizations. We're simply referring to the law that's been developed at the federal and state level. So if you've got recognized defenses at the federal level, you would have them in this ordinance as well. Again, it is not the intent of this ordinance to apply new regulations on religious organizations that are not required under federal or state law. I have suggested not listing the various exceptions that are out there, because the exceptions can change over the course of time based on the case law and how it develops. So basically, whatever the state of the case law is, and we will be mirroring the EEOC as it relates to the applicability of religious liberty exceptions to various practices. They would exist under this particular ordinance as well. General considerations just for you to think about. Whether we do all employers within the city of Charlotte or just the employers below 15 employees, this will be something that's new for that community. They have not been subject to these EEO laws before, so there's going to be some need to get them up to speed as to what the practices are, what the state of the law is, and again, this would be something new for them if you enact the employment piece. City administration, there may be, I would anticipate again, particularly if you enact the employment piece, there may be more complaints that we didn't normally receive in the past. So we'll have to make sure that we've got the staff resources to be able to process those complaints going forward. We've never done it before, so I can't really predict what that's going to look like. But if the employment piece is passed, I would expect that there will be more work to review complaints coming out of that. Potential litigation, I've seen some media reports that whatever it is that we do, we're likely going to get sued. I've put together a lot of ordinances over the course of my career, and I always assume that someone was going to challenge these ordinances, so I try to look at the ordinance to make sure that as best I can, it doesn't make some mistakes or silly mistakes that will automatically get us bounced out of court with an injunction preventing us from going forward. And as you all know, if there is a successful argument that there has been we've exceeded our authority, our statutory authority. We also have to pay attorney's fees in that case as well. So we take that into consideration as we're putting together these ordinances, and believe we've taken some of those considerations to the extent that we can identify them into the ordinances that are in front of you today. Also, the General Assembly, again, I can't stress enough that we are not regulating bathrooms, that we are not doing anything that violates the remaining sections of HB 142. But keep in mind that the General Assembly at any time could step in and preempt local governments from enacting these employment discrimination ordinances, similar to what they did when they did HB 142 in the first place. But it's just something for you to consider going forward. Finally, and I realize I skipped past the fair housing piece, there have been questions about why aren't we amending the fair housing ordinances as well. Fair housing, unlike the other ordinances, is actually a creature of our city charter, where we've gotten specific authority to address specific discrimination in fair housing, and that also includes sex discrimination. It also includes race and national origin discrimination as well. And if we're going to make changes to that, if we use the now defined protected class and applied it to fair housing, that would necessarily change our directive in the city charter. And as you know, we would need to go to the General Assembly to get that city charter changed in accordance. We can't just do that on our own. As it relates to fair housing, though, I do want to be clear. HUD, which assists us in administering fair housing, has applied the Bostock case to the term sex for sex discrimination. So gender identity, gender expression, and sexual orientation would be part and parcel of sex discrimination in our fair housing ordinances. And the same argument for natural hair discrimination that I raised before, I believe would be applicable under the race and national origin prohibitions in our fair housing ordinances that exist. So we get there to, I believe, the same place, just in a little bit different mechanism, but certainly we could ask for specific charter authority from the General Assembly if we wanted to apply the currently proposed definition of protected class to include the protected classes in the housing ordinances. So with that, we'll take some questions.
All right. The city attorney has finished the presentation of the history and the recommendation that he is making for a non-discrimination ordinance. And so with that, I would like to recognize Councilmember Eggleston.
Thank you, Mayor, and thank you, Mr. Baker. Got a couple of things that I want to touch on as we start this conversation. One, for both those of us on council and for the people who are watching or following along at home, I do want to make sure that we're all looking at the same version of this ordinance. There was a version with a handful of edits that was uploaded to the city website this afternoon. So if anyone's pulled up an older version or they're looking at something from a week ago, there have been some changes made, and I think it's important that we're all working from the same document. So people in the public can go to the city website where the city council agendas are located, and there's a hyperlink to a PDF of the most up-to-date draft that's available on tonight's city council agenda, and very easy to find because it's only a 2-page agenda. It's also in, for those of us on council, it's in our iLegislate as an attachment to the agenda there, just so that we're not debating a point that maybe has already been updated. Mr. Baker said it, I think 3, if not 4 times, but I think it bears continuing to repeat. We're not doing anything here that is expressly prohibited in state law. There's no longer, with this draft or something close to this draft, there would be no reasonable or logical cause for a response like what we saw some years ago in the form of House Bill 2. And so for those in the community that might have PTSD from House Bill 2, just know that that's something that a lot of consideration was given to making sure that we don't open ourselves up to that sort of a response again, that we do what we can. And as Mr. Baker said, we have not wandered into the territory that we're expressly prohibited from wandering into with those exemptions that were drawn out in House Bill 142. there have been some questions about, in this most recent draft, the elimination of a couple of sections, but I would concur with our attorney. There's no need for us to flesh out the things that this ordinance can't and does not do, things that are prohibited by state law. If we started to add in all the things that municipal government in North Carolina cannot do, based on state law, we would have quite the long novel instead of an ordinance. So I think in this case, the fact that we are in compliance with those things, we don't need to expand or expound on what those are. There's no need for those to be in there any more than there is for every other thing that this ordinance doesn't do or can't do. But on a happy note, I think that as we start this conversation, I think it is worth drawing attention to the fact that we've got a bipartisan council here who is in agreement that this ordinance needs to be in place, that we need protections for people in our community. And I think that's something that we should applaud, because we've had a number of issues this year that have been divisive, have split the council, have at times created odd bedfellows. I think it's pretty awesome that we've got something like this that a couple of years ago it would have been unfathomable that an entire council would agree, at least in principle. We might debate the details here tonight, or some of the finer points of it, but agree in principle that this is something we want and something we need. And so I hope that this is the start of something better for this term, because having an issue that we can all rally around and again can have a healthy debate on the fine points of, but agree that the LGBTQ community in our city needs protections, deserves protections, and we want to provide those protections. So I do kind of feel like we're all in this together, and I hope that our discussion tonight is reflective of that. My one question for Mr. Baker, and my suggestion, if it's the will of a majority of council for an amendment to this post-updated draft, is as I look at, if you scroll all the way to the bottom of page 6 of this ordinance, it says this ordinance shall be effective on January 1st, 2022. In conversations I've had with Mr. Baker and his team, I understand and would ask him to expand on some of these details. I understand that we need a little bit more of a runway timeline-wise for some of the employment pieces, and I think he can explain why that is. That said, and I know some of the other cities in our state who've adopted ordinances before we are scheduled to in a week from now, have effective dates of January 1st. That said, there are other parts of this that I don't think need that long of a runway, and I would ask Mr. Baker, what pieces of this could be implemented and made effective sooner? How soon could they be made effective? And I don't know how we want to go about this in terms of logistics tonight, but I would ask if there is a majority of council that would agree, based on what his response is, to split this into maybe two different timelines. One being the employment piece, which you might make a case does need to be January 1st, and the parts that don't need that long of a timeline, something much sooner, because I know that every day we wait, these protections are not in place, and I know the community wants them in place yesterday. But the best we can do is the day after we adopt it, and I'm wondering if that's an option. So I hope that he can shed a little bit of light on that, and then that my colleagues will agree with me that the pieces that can be done faster should be. Thank you.
All right, thank you. Mayor Pro Tem?
Thank you, Madam Mayor. I too want to thank Mr. Baker and your team for all the work that you've put into this. I also want to thank the LGBTQ community that has put a lot of time and thought into this as well, and to council members who have also spoken up and asked questions. I do ask if Mr. Baker could give us some clarification, however, on the issue of underemployment. If there is a complaint that is brought forth to this Community Relations Committee and they attempt to start a conciliation process, but the employer chooses not to participate, under our existing non-discrimination ordinance, we have a system and fines in place if someone doesn't show up. Could you just explain what that is, and please clarify if these additional classes are are also covered under the same conditions or the same system?
Thank you for that question. As it relates to complaints that are going out of the employment discrimination ordinance, yes, it would go to the CRC first, and they would do an investigation. If they find reasonable cause to believe that discrimination has occurred, that's when they would reach out to start the conciliation process. Assuming that the employer chose not to participate, then the investigation would then be referred to the city attorney for further appropriate action, which could include, again, going to court to seek equitable relief and injunction to force the employer to change their practices. But yes, there are fines that are also part of our ordinance mechanism that we have in place. Though we haven't done private employment before, and again, unless you add that to the ordinance, we don't have that experience. I have spoken with Willie Ratchford, who is the director of that department, to find out what happens when conciliation fails, and for the most part, conciliation rarely fails. The amount of times that have had to be referred to the city attorney, I think he said in his entire career may amount to 5 times, and those were out of the, I believe, the fair housing side as well. But employment, we have no history with employment, so I can't tell you that that's going to be the case as well. We just, as an organization, don't have much experience with a cause finding that is unable to be conciliated between the parties. But it is quite possible, and as we're putting these things together, we have to assume and be prepared for potential situations where there's just no agreement, and that we have to then employ those additional remedies that we haven't in the past.
Okay, thank you.
Mr. Baker, can you go back again and just remind me what you said about the timeline? If it was employment was January 1, are there other areas, or is that something that you're going to send to us?
No, I can address that now. The main reason for the January 1 timeline was in anticipation of an enactment of an employment discrimination ordinance that I believe the administration and the attorney's office would need some time to get up to speed, if you will, in terms of who's going to be doing those investigations, because right now that is not what the CRC is doing. Once upon a time, the CRC did handle employment discrimination claims against the city, but we have not done that, according to Mr. Ashford, in roughly 20 years or so. So I don't know right offhand what the bench looks like in terms of understanding of employment discrimination law, but I would expect that it would be several months to get ramped up. That, to me, Section 4 of the proposal is the part that I think would need some time. I will check in with staff as well, but I believe that the other pieces, because they are already active and moving, you're simply adding the new protected class to it, the definitions of sex as put together in Bostock, the natural hair piece as well. I think that can move much quicker, maybe within 30 days, maybe sooner. I'm not exactly sure.
So I would just add this as a thought that if we were going to vote on this on August the 9th, the agenda would go out on the 5th, on that Thursday, and we could have that comment included on the 5th. Is that?
Yes.
Okay,
yes,
thank you. So when we have the agenda go out, the answer on the effective dates, a recommendation from the attorney's office will be included on Thursday. All right. The next council member is Councilmember Newton.
Thank you, Madam Mayor, and I appreciate you bringing that up. I was just about to say that I am completely on board with that suggestion that Councilmember Eggleston had made. The sooner that we can get as much of this enacted, assuming this passes next week, as much of this enacted as possible, I think the better. I know that there are many members of our community that have waited quite a while for these protections, and I think that would be warranted. I'm also glad, mentioning that, I'm glad that we're finally here having this conversation as well. I want to thank you, Patrick, for all of your hard work on this. I want to thank my colleagues for all of their hard work, and for all the many members of the community that have been a part of this conversation for all of your hard work as well. Wanted to mention a few things here for us as council members to hopefully consider before we do vote on this next week. A couple of items to maybe discuss and talk about. I know that it's not uncommon for us to talk about covering gaps in what we do. I think we traditionally talk about that within the context of financial gaps, and there's a lot of utility there, right? Because we know for a fact that if we're covering financing that goes beyond just the immediate financing need, it truly is redundant. We are spending more money than is necessary. We're engaging in more activity, right, than is necessary, and actually depriving ourselves of engaging in benefits in other areas or enacting benefits in other areas. I really question if that holds true here. And I've given this a lot of thought. I know you and I have talked about this, Patrick. But the more I think about this, the more I really question whether we really should lock ourselves into this gap provision of sorts for employment, and not just extend protections to people in the context of all employment, regardless if that employment is 15, 14 employees or below, or 14, 15 employees or above. I understand that there are cities across the state that have enacted ordinances that do apply to all employment. I think you might have mentioned that in your presentation. And I feel like, sure, there are state and federal protections, but what's the harm in us also enacting additional protections? That's not something that's outside the context of or is illegal or outside the realm of possibility, from what I understand. Correct me if I'm wrong on that. I mean, frankly, you look at the fact that there are state and federal protections, they overlap, right? And so it really provides more options, right, to fight discrimination. And I feel like in the context of providing those options, we should do that. We should help as much as we possibly can to eliminate the possibility of discrimination happening. Certainly if we're serious about this. So I just don't see us maybe expanding our employment protections beyond 14 or less to include all employment as redundant. I see it more as providing an additional option for our residents within the city, and possibly even an insurance policy for our residents within our city, because we don't know in the future what might happen, right, under federal or state law. So I really question whether we would want to lock ourselves in that regard. I appreciate how, when we talk about penalties here, I appreciate how we have this process in place with the CRC reviewing complaints, making a decision, right, independent of the council as well as the city attorney's office. I can tell you that within the context of seeking an injunction, that there are penalties that are associated with that. If there is any violation of a court can institute financial penalties and fines, could even put someone in jail, frankly. But at the same time, I think from the context of us ensuring that we do prohibit these forms of discrimination that we're talking about here, I really question, too, whether we want to maybe take this a step further. I mentioned a moment ago that there are ordinances across the state that have items that are a little bit stricter than what we're considering here. And I feel like, they're not being challenged in court. So why wouldn't we follow that example? In this instance, when we're talking about penalties, there are other ordinances that include fines. I think they range from like maybe $100 to $500. There is some question as to whether, if something like that was instituted, if that would be something that would be an ongoing fine. But I feel like to really prohibit this type of discrimination that we're talking about, to provide that deterrent, that's maybe something that we should also consider, placing some fines in there that will function alongside any sort of penalties associated with injunctive relief, which could take quite a while, right? 30 days, and then however long it takes to go to court, get the order from a judge, which could be another month, 2 months, what have you. Hopefully it wouldn't take that long, but we don't know for a fact, right? So I just wanted to put that out there for my colleagues as well. The housing piece on this too, and so just for anyone asking the question, I know I had this question about how we would prevent this type of discrimination in housing. I think you answered it for me, Patrick, but I just want to touch on it. You had mentioned that it's within our charter, and so that protection, for all intents and purposes, already exists, is what it sounds like. Is that correct?
That's correct.
Okay. I don't know what the enforcement of that would look like, what penalties may be attached to that. It sounds like it is prohibited under our charter, but could you speak to how that would function if someone were to violate that part of our charter? What are the consequences?
So it is, and I don't know if Mr. Ratchford can speak to that because his department is very vested in those fair housing discrimination complaints. They would do their investigation, as I understand it, and if they find cause that the fair housing discrimination has occurred, they would attempt to conciliate between the landlord and the tenant is typically how it works. I don't know that they have failed to conciliate in the past. I think it's been a many years that it's happened, but there are potential fines that are associated with that. There are default fines related to violations of our city ordinances. And again, I don't know if Mr. Ratchford can speak specifically to that or not. I'm happy to turn the microphone over to him if he's available.
We're going to get Mr. Ratchford to come in I think you said that over his career with the city, there have been 5 that have gone beyond conciliation. And I think Mr. Ratchford has worked here at least 40 years. So I think that he's either very skilled conciliator. I don't know, they could have used you in Goodfellas or something like that, right?
No, I need to hear the question. Okay.
Mr. Newton's question?
Yes, Mr. Newton, could you please repeat the question?
Yes, sir. Thank you for being here tonight, Willie. I appreciate it. I know everyone does. So my question was within the context of housing discrimination, particularly on the basis of sexual orientation, gender identity, natural hairstyle, and the other categories that we have identified here tonight. If there were to be someone who were to deny someone housing on those bases, engage in that type of discrimination, certainly our charter would prevent that. But what are the consequences when that occurs?
Okay, so let me make sure that I am understanding your question. If someone files a complaint on any basis, we will start an investigation process, and actually we have a twofold process. Conciliation really should start at the very beginning of the process, and it should run separate and apart from the investigation, such that we might receive a complaint. We inform the respondent that we would like to conciliate it while we're in the process of investigating. If we're successful with that conciliation prior to completing the investigation, then we would close the case administratively without making a finding of fact, because the investigation itself is designed to get us to conciliation itself. If we make a cause finding and we attempt conciliation, if we're not successful, the ordinance then requires that we have a public hearing, which consists of 5 members of the Community Relations Committee who are appointed by the chairman of the Community Relations Committee. And those 5 hearing officers would hear both sides and make a decision as to whether they think the finding that the Community Relations Committee staff investigator made was correct, or if the respondent has a prevailing argument that says that discrimination did not occur. If the hearing panel agrees with us, then by law or by ordinance, we again are required to attempt conciliation. And if we're not successful with that, then we take it to the city manager, The city manager's workload is already big enough. He doesn't need this. We take it to the city attorney's office, and then they would then file a lawsuit against the respondent.
Okay.
But as far as any potential fines for failing to conciliate, there's nothing in the ordinance that covers that.
Is that, and so Patrick, my question would be, is that something, seeing as how it's a part of our charter, and I understand the effectiveness of filing suit, don't know if that would include injunctive relief. I think it probably would, right? But what challenges might we be faced or be posed with if we were talking about something to the extent of, say, fines, like it sounds like we would be much more able to do in these other contexts, employment and taxi cabs, et cetera, that we're talking about within the ordinance now? What challenges would we face if we were to take that additional step in our charter?
So, Mr. Newton, I've not looked at our charter authority for that specific question, but I'd like to determine whether or not the charter authority speaks to what the remedies are and why we're using the remedy that we've been using and whether we've got that flexibility. But that's a question that I've noted and can certainly provide that response to you quickly.
Thanks so much. I appreciate that, and I really look forward to having the conversation with my colleagues here over the next week over some of these other points that I mentioned. Thank you.
Mr. Newton, I think this is the time to have that conversation. You know, we set up these meetings so that they are actual discussions, and you've asked, I hope that I've captured everyone, but you've asked whether or not we should have more restrictions like other cities, and I'm not sure what the comparison of your other cities are. You have also asked whether or not we should increase the penalties with fines, actual fines in that area. But I think this is the time that we actually are supposed to engage in this discussion. As I said, this goes out on Thursday as a recommendation, but it's very helpful for the city attorney to know the guidance from the council to prepare for that distribution of the agenda. It also helps us bring forward whatever we're going to do to the community, because when that agenda goes out, I can't remember how many people and get it, but that's the item that people are expecting us to vote and debate and then vote. So this is the appropriate time. I don't know if anyone on the council would like to respond to Mr. Newton's question. So, Mr. Newton?
And just to clarify, so I think I have 3 points for discussion. The first one would be whether we will broaden our protections in the context of employment to include all employers, rather than just employers who employ, is it 14 or 15 or less
14
employees, so broadening employment. That's my first one. The second one would be assessing whether or not we would want to have fines levied against offenders alongside the possibility of injunctive relief. Now, how we assess what those fines would be, I think would maybe be, if we want to pursue that, would be the next topic of conversation, how much, whether they would be ongoing. And then the third one is whether or not to pursue any additional types of penalties for relief, fines, in the context of someone violating or engaging in housing discrimination under our charter. So those would be the 3 points I think that, I was bringing up.
Okay, so I know Mr. Driggs has raised his hand, but I'm going to ask Mr. Driggs, are you addressing one of those, or do you want, let me start again. Would council like to hear from other folks that have got questions for Mr. Baker, and then come back to Mr. Newton's 3 questions for discussion? Is that, Mr. Driggs, you have your hand up?
Yes, Mayor. It wasn't in response to Mr. Newton's questions. I just had some of my own.
So I'm going to go ahead and have every council member that would like to address questions and complete that, and then we'll come back. So, Mr. Driggs, I'll try to do a better job of listening for the questions to make sure that council responds to it. And then following Mr. Driggs, we will have Mr. Phipps.
Thank you, Mayor. I wanted to say first, I agree with Mr. Eggleston that there is a consensus among us on the issue of wanting to prevent any mistreatment of members of these new protected classes I'm certainly in agreement with that. I think it's wrong if somebody is denied a table in a restaurant or suffers in any way by virtue of their membership in one of these groups. And so I'm hoping we can reach a conclusion that I can support. There are some issues, though, and I think we need to be aware that this environment is contentious, and we would not be doing justice to the subject if we weren't kind of respectful of some concerns that people might have. Now, in my case, the biggest concern is about the employment. The federal government expressly did not include these small employers, 14 and below, in the safeguards that it put in place to prevent discrimination, and which have been in place since the 60s, as we just heard. They've been in place through various administrations and majorities in Congress, and that extension down to the smallest employers has never come up or been acted on. And I think there are reasons for that, and we need to think about what those reasons are before we go into this arena with good intentions. We also have a responsibility to small businesses, and we have lately engaged in various relief efforts on behalf of small businesses because of the effect that COVID had on them. We have acknowledged the importance of small businesses in creating jobs and opportunity for members of, in fact, some of these protected classes. And to take an action that could place a burden on small businesses that is not in line with the rules that they have to play by according to state and federal law is something we should be thoughtful about. And I'll explain why this is an issue. The problem generally with non-discrimination, and I say this as somebody who had subordinates in my professional life, the problem that can arise is that it basically makes members of the protected classes somewhat untouchable. It means that if you have an underperforming employee who happens to be a member of a protected class, the remedies that you would have against an employee who is underperforming and wasn't a member of a protected class are more limited. And you have to be prepared for allegations that any action you take against them or any failure to promote them or anything else is going to result in some sort of a protest, legal action, or whatever. This is particularly important for these small employers because they just don't have the resources. They don't have the time to show up at all these hearings. They don't have the lawyers. They do not have the ability to defend themselves against these actions and could therefore find themselves in certain circumstances being held hostage by somebody that was legitimately non-performing. And I want to emphasize that this is not about the fact that they are a member of a protected class or not. It's about the fact that they are an underperforming employee. This happens. It happens among people who are not in a protected class and those who are. So we have to be mindful of unintended consequences when it comes to putting this burden on small employers. And one question I do have, I guess, for the staff, I'm not sure who this is addressed to, what kind of outreach have we done to find out whether employers in this category are concerned about the effects that our ordinance could have on them? Have we engaged? Do we have input from them? Did they participate in the formulation of this? Can anybody answer that?
I personally have been on the phone, I think, on Friday with some business interests that were specifically asking questions from the small business perspective. But I don't know that I don't know how much engagement has occurred beyond that one conversation from my perspective.
Can I just...
In any case, I would like to hear more from them and be sure that this possibly theoretical concern, but again, from my experience working with a large employer, we spent a lot of time and money on lawyers dealing with the existing non-discrimination provisions. If you had an employee, for example, who was past a certain age and was really out of touch and was not performing anymore, you knew that there was no way to end that employment that was not going to invite some sort of a counteraction. And usually what happened was you had to offer them some sort of a package or incentive in return for their signing a waiver of any action they might take based on the fact that they were of a certain age. So I do feel this is an issue. I'd like to get more comfortable about it. And again, I feel all discrimination is bad. I think it's bad to discriminate people against who are small of stature. It's bad to discriminate against people who went to the school you don't like. So it's difficult when we create these protected classes to suggest that anybody who's not in a protected class can be treated any which way. I was interested to hear
Mr. Driggs, Mr. Driggs, Ms. Iselt wanted to respond to your comment about the businesses. Do you want to, is that okay to do that now? About the small business engagement.
I'm not yielding. I'll take a question, but I have others.
Oh, you asked the question, and so Mr. Baker answered, and she would like to also address it. And then we'll come right back to you.
If anyone has that information, and I just wanted to put it out there that the Charlotte Small Business Coalition, and I believe the Alliance, the Charlotte Regional Alliance, is in support of this.
All right. I haven't heard from, I know some small business people. I'd just like to find out for myself. If they're doing that, that's good. I'm still concerned that if the federal law expressly, it wasn't an omission on the part of the framers of the federal law, it was a distinct provision where they said anybody 14 and under is not included in these protections. And I think there could be a question, and I believe the lawyers are suggesting there might be a question as to whether for us to take upon ourselves to afford those protections to them in fact violates the intention of the federal law, because it is not inaction in the federal law, it is an action of the federal law that they are not included in federal protections. Mr. Baker, you were talking about the sequence of events, or actually I think Mr. Ratchford was, including the possibility that if the thing makes its way back to the city attorney might sue. Is that right? Could this end up in court?
Yeah,
and if so, based on what statutes?
So out of the ordinance, the way that the ordinance is written, there is the conciliation efforts, and it would be referred to the city attorney for, I think the words are further appropriate action, is what's in the books right now, and that is the basis of the authority is coming directly out of our ordinances. That's what's on
right,
the
I get
books.
that, but this is a critical issue, what the remedies are, and so far we have this thing making its way to the desk of the city attorney. At the end of the day, what can happen to somebody who is uncooperative in this process?
If there's a cause finding of discrimination under the ordinance, and we're not able to conciliate, and they're only coming the employee are only pursuing remedies under the city ordinance, not state law or federal law. That's a completely different animal. Then what I am suggesting is the language of the ordinance speaks to the city attorney seeking further appropriate relief, which for the most part would look like a lawsuit brought in civil superior court seeking an injunction to enjoin the employer from continuing to employ the discriminatory practices. It's not been done before, is my understanding, but that's, I believe, how it would play out.
How many actions have been brought to the, of any kind related to discrimination? You mentioned there were only 5 actions that have made it to the attorney in the past. How many under the existing non-discrimination ordinance cases have actually been brought to the Civil Service Commission? No, the Citizens Review, the body that looks at these. Is this common?
Mr. Driggs, in the 41 years that I have worked for the Community Relations Committee administering the Fair Housing Ordinance, we have had 5 actions that have been referred to the City Attorney's Office, and on at least 4 of those, they were resolved before any court action was taken. Maybe on all 5 of them, they were resolved before court action was actually taken. You had mentioned earlier some concern about a low-performing person using a protected status as a way of getting around the law. Everybody in this room, everybody on this call is a member of some protected class. You can't get around not being a member of a protected class. Everybody is.
I'm certainly protected on the basis of age, so I feel good about that. Thank you, Willie. Mr. Baker, you referred to the fact that there are federal laws that relate to religion and to the extent to which people are protected by virtue of religion. I guess offline, I'd like to know a little bit more about what those are and therefore what the environment would be for protection on religious grounds in our ordinance. Here again, the problem is that there are some people who have valid conviction, and the fear is that there are some people who would plead religion when it's really just malice. And our challenge is to make the proper distinction between those two and not impose on somebody who has grown up or demonstrated by other behaviors a lot of sincerity and conviction about their beliefs, to make them to do something that violates their beliefs while not allowing others to claim that they have a religious reason for discriminatory action, and in fact they don't. So if Mr. Baker, if we could just follow up on that one and help me to understand how much protection there is under federal law as it relates to people's practice of religion. So I guess I'll just conclude by saying I'm very, very supportive generally of the goals and most of the content and of protected classes. I am worried about the employment thing, and I want to make sure that other people's rights are not infringed on as we go to protect those members of these protected classes. Thank you.
Thank you, Mr. Driggs. I have the following council members, and we'll go in this order: Phipps, Mr. Phipps, Mr. Bakari, and Ms. Johnson. So, Mr. Phipps?
Yes, thank you, Mayor. I wanted to get some clarification on the inclusion of our protected classes. I mean, we have sexual orientation, gender identity, gender expression. Is that going to be, I guess, lumped in a parentheses under sex, or are we still going to list those as protected classes? The same with pregnancy, which you said we could be under sex, and natural hairstyle could be under race and national origin.
Yeah, that's a very good question. From my perspective, I like to stay in what is a protected class. Right. So rather than putting out, multiple phases or perspectives of a protected class, it's just this is the class. Given the conversation that has occurred around sexual orientation, gender identity, gender expression, is where I added the parenthetical to make sure that folks understand that those particular divisions of sex discrimination are part and parcel of sex discrimination. So ideally, it would you would continue to just use the word sex discrimination as the protected class. But given the recent changes coming from the Supreme Court, I just want to make it very clear that sexual orientation, gender identity, gender expression are part and parcel of sex discrimination.
And that's the same with natural hairstyle, with race and national origin.
Yes, and I do want to be clear about the Crown Act because there isn't an applicable Crown Act in North Carolina yet, either at the state level or the federal level. But everything that I've seen coming out of those jurisdictions that have imposed the Crown Act essentially say that can be the basis of a race or national origin complaint, which are already part of those well-established protected classes going forward. So you do have, it appears to be a legitimate fact-based argument. Again, depending on the circumstances.
Okay. Another question I have relates to on page 2, you have some mandatory non-discrimination contract clause in it, and it speaks to, I guess, if a business is, held to be in violation of discriminatory practices, that it calls for disqualification of the company from participating in the city contracts or other sanctions. My question is there a time limit by which a company can be reinstated after having successfully adjudicated its case and provided sufficient remedies? So is this a disqualification forever? Or is there a redemption period in there?
It is not a disqualification forever. I don't have the specifics on what that looks like. I don't know, Mr. Rutchford, if you've... Yeah. I know that, well, I'll tell you what, I will get you some information rather than.
How about if we just
yes.
send that out on Thursday?
Yes.
All right.
Okay, and my last question was, I guess, answered when you asked when Mr. Driggs asked it about. I was looking for available metrics from the Community Relations Committee about the volume and scope of discrimination classes, but you've answered that it's been like 5 and 41 years or something like that. One other final question I had about when you find, when the CRC finds that there was no violation, it says in this document that we got that you would inform the person in a reasonable time. What exactly is that? What is this reasonable time? Is there a specific time?
The standard that we have used since I have worked for CRC has been 10 days.
Oh.
Within 10 days of a no, what we call a no-cause finding, where we believe discrimination did not occur after our investigation, we will inform the respondent and the complainant as well as HUD that we've made a no-cause finding and that the case is being closed out.
Okay. Thank you. Just the extent of my questions right now.
All right. Mr. Bakari?
Thank you, Madam Mayor. Well, first and foremost, I want to say thank you to the group of young Republicans who have done over 8 months of hard work, led by Kyle Lubke, who's with us in the room today, as well as Maya Pillai and Brad Thomas. Your tireless work over these months and months and months, working sessions, have been so much appreciated. And you guys have really worked together to do something I think really special with conservative principles for the first time that I've seen, which is thread a needle that is so complicated and difficult and really walk that fine line between protecting against all discrimination, but also not infringing on the rights of folks and basing that in that conservative principle of individual liberty. It is really amazing the work you've done and put in, the conversations you've had, and all along kind of protecting those that need protection while not requiring adoption of those beliefs and not infringing on other rights. And I think that if we could do more work like this ongoing, the world would be a better place. So I first and foremost applaud you for all of that work, and thank you so much. I think that your work also is a reason why we're here in many cases today. Many have been working on this for a long time. Many care deeply about it, but I think there's no doubt that your work and what you've done there has pushed the conversation to another level and definitely helped apply the pressure that brings us forth today. So with that, a lot of things have been incorporated that I think probably wouldn't have otherwise that we see in here, and I applaud that. There are 4 things left in this version that has been rolled out that are in a range of concerning to me all the way up to things that unless we rectify in the next week, I can't be in a position to support it no matter how much I'm appreciative of how we've gotten here. The first one, and Councilmember Phipps already kind of mentioned this, but I'll hit it again. I hadn't seen this come up before, but around the city contractors piece, requiring all these companies to attest up front in this affirmative, proactive way, while maybe well-intended, is probably riddled with unintended consequences that I don't think are necessarily worth the squeeze ultimately there. Having been in a career with vendor management and things of that nature, you know, saying someone has to do and comply with certain things and then we will hold them accountable in a reactive kind of manner with the CRC is one thing. Having them proactively have to attest that they will adopt the policies that the city utilizes internally and have those in place. I mean, there are so many small businesses that could never, ever do something of that nature. And I think there's got to be a way to respect the spirit and intent of what we're trying to do without putting crushing bureaucracy on all these folks. So that's the first one. The second one, and I'll just give you an example here because this touches both the broadening of that employment beyond 15 as well as housing. If a black woman, for example, with natural hair, right now, after this proposal would be in place, would be able to be fired with no recourse at a company with 15 or more employees, or would it be able to be discriminated against when seeking to buy, for example, a home that's for sale by owner. So these are two very specific cases and examples, and then there are others in the other topics with LGBTQ plus community and others, but these are two examples that would be exposed and at risk, even with the current draft language. So we need to look at that employment and housing concepts that did not mirror that of which the Young Republican version has been brought out. Third, here's another example that is not protected explicitly after this version would be voted positively in this manner. A religious organization, school, or nonprofit could be forced to go to court to ensure it doesn't need to hire someone whose actions go against their beliefs. It's quite clear, and I think you would agree, Mr. Attorney, that they wouldn't, per the Supreme Court. However, when we aren't clear in our ordinances, the only alternative is for them to have to go to court. And that's costly, that is a process that bogs down the system. There's no reason for us not to be clear and explicit in our statements there, even though they may be unpopular with some support groups that don't want that explicitly stated. And I'd go forward further to add that removing the things that we are explicitly stating in our version, like religious protections or like clearly addressing the bathrooms that were in the previous version, that's not just dangerous. I think it's a root cause of what happened in HB2. Communicating with our partners statewide and otherwise and explicitly showing them we're just as concerned of protecting rights that they care about is not just good practice, it's how we make sure we defend all of those that are in need and we don't end up getting in some kind of protracted fight. And then finally, the fourth item, in the current version that's different than our version that we brought out, a Republican, for example, could be fired from their job just because they're a registered Republican or they marched in a protest and it was seen by their employer. A Republican could be denied service at a coffee shop because they're wearing a Republican-themed T-shirt. So creating this protected class for political affiliation or expression is not only relevant in today's environment, it is the beginning of an antidote for the cancel culture we have come to unfortunately expect. We must oppose all forms of discrimination if we're truly for this path we're going down. So I hope that one day all of this protected class conversation that we're having here is not necessary and we're beyond it. But for today, I think it's a reasonable approach we've come to. And if we can address those four items, I think we'll be in a good spot a week from now. Thank you.
All right. Ms. Johnson.
Thank you. I just had some questions. I had reached out to the city attorney to ask a couple questions, and I wanted to get those answers if we could publicly. What percentage of employers will this affect who have 14 and under employees in the city?
So I know the overall number of 14 and below is something in the range of 13,300, and unfortunately I didn't do the percentage. I don't know if someone knows off the top of their head the number of employers that we have. I was focused on the number of employers that would be impacted, but I can certainly get that for you quickly.
Okay, thank you. And we also talked about criminal background being a part of that language. Can you talk about that?
Yes. So I've not seen any ordinances that specifically call out criminal background and make it some sort of protected class. But what I have seen is that the misuse of the criminal background process could create a race discrimination claim based on how they're using it. For instance, the inconsistent application of a criminal background process. So you're using it for some people and not others, and it may be based on race or sex or national origin or what have you. That could be cause for a discrimination claim depending on the facts of those cases if there's inconsistency in the application. And I've also seen arguments made for potential disparate impact claims, and that is where, particularly when the actual criminal prohibition that you're trying to address, the crimes or the convictions that you think are disqualifying, when they're not really tied to the employer's business relationship, if you will, or a business necessity, and that it has a disparate impact on a certain protected class, that could also be create a claim, if you will, of discrimination.
Okay. And also, one of the things that Willie said, that you'd only seen 5 claims go to the city attorney in 46 years. I would argue almost or bring up a concern if the public is aware of this, of the process, the CRC process, because I remember the conversation about the source of income discrimination. There were only 2 or 3 cases that you were aware of, but I have a text from someone that had reached out to 32 complexes just in 6 zip codes yesterday, and is getting the answer that they don't take the source of income or take the housing choice voucher or whatever voucher. So I think there's a bigger problem out there that maybe the information's not being captured. So for that reason, I would want in our draft, Patrick, if you could delineate or really outline what the course of action or what the recourse is, because we've asked directly if a lawsuit was a part of it, but even in the answer, it seemed very descriptive, like the lawsuit would say, please don't do that anymore, or whatever the language was, but I didn't hear monetary. And so I also want clarification on what's the difference between going to the CRC department for that process, conciliation, and then being referred to the city attorney's office versus private cause of action. So what is the difference there? If you can answer that now, if you will, and then also maybe put that in writing so that we're clear.
So local governments have the authority to enforce their ordinances, either through fines or some other process that's set up within the ordinance. But what I haven't seen is the local governments having the ability to basically, as in the EEOC case, when the EEOC does a review of a discrimination case, they can give you a right to sue letter, and that is the ticket that allows the private entity, the private employee, to get legal counsel to bring a lawsuit against their employer. I've not seen that type of, and I don't know that we have an authority to say that here is your right to sue on the grounds of a city ordinance. Cities are given the power to enforce their ordinances through typically fines or some other process like we've created here with the CRC, or some, equitable injunctive relief is typically the statutory provision for a city enforcing its ordinance. But I've not seen a situation where a city can have its ordinance enforced by giving a private entity a right to sue on an alleged violation of the city ordinance. I'm sorry.
Yeah, that's okay.
Yeah.
I'll just have to see that in writing, maybe the comparisons.
Sure.
Because it sounds like ultimately they have a right to sue, right? If it goes through the steps of the CRC and the attorney, it sounds to me like the outcome is the same, or the recourse is the same.
Yeah, Ms. Johnson, under the current fair housing law, we do not have, to the city attorney's point, we do not have the authority to grant anyone a right to sue after, say, a no-cause finding on a fair housing complaint. We do advise them that they have a right to sue, but and it stops at that point. We simply advise them that we've made a no-cause finding. We don't have reason to believe that discrimination happened based upon our investigation. However, if you disagree with that, you have the right to sue if you choose to, and it stops there. But we don't give them an official notice notice letter of right to sue. We're not authorized to do that.
Okay. Then maybe if you will describe or explain what is private cause, and that's private cause of action, or and so then I can hear the difference, and maybe when you send that out Thursday, I can't be the only one who's not clearly hearing the difference. So what is private cause of action versus what the proposed recourse will be?
When I say private cause of action, I mean giving the citizen the right to sue, bring their own legal action in their own name, with their attorney or without, against an individual for violation of a city ordinance. That's what I mean. And I will provide more information to clear that up for you.
Okay, but in our case, the proposed recourse is that the city attorney would bring the action.
That's the mechanism that you have right now on the books, and I put the employment piece in that same vein as the public accommodations piece, simply because we've already got a system there and was just trying to keep it consistent.
So this is a stronger, or could be perceived as a stronger level of enforcement,
yes.
right? Okay,
It just hasn't been used very often, getting to that level.
okay, thank you.
All right. I think what we're trying to do tonight is to give the city attorney sufficient guidance of some sort to craft something that would come out to us on Thursday, in addition to the questions and responses that he has committed to do. So what I'd like to do is start again with Mr. Newton's and have first
Are we
three.
done with the
Oh, I'm
questions?
sorry. Mr. Winston, I looked over there and I did not see Winston up, and I did not see Mr. Graham up. So let me start again. Before we do, let me just make sure, I think I've heard from everyone except Mr. Winston and Mr. Graham. Is that correct? Is there anyone that would like to speak? Okay.
Mayor, I have one more question when you finish the round, just a short one.
Okay. We'll start with Mr. Winston, and then we'll go to Mr. Graham next.
Thank you. Mr. Baker, I believe in Section 4, we should explicitly acknowledge in the ordinance the existence of the state and federal protections for employees of employers that employ over 15 people by citing the general statute and the U.S. code that protects such employees. Is that possible to do?
So essentially what I'm hearing is that you want the employment discrimination ordinance to include all employers in the city, not just employers 14 and below?
No, sir. I see in Section A, I don't want to add to Section A. If there's a Section B to be added, the acknowledgement that protections do exist, but they exist on the federal and state level, and we should dictate, so when, for instance, this ordinance is a resource, right? When an employee believes he or she has been discriminated against, or they have been discriminated against, they would go to the law and say, hey, look, I have something to back me up. They should know when they look at our local law, all the places that they can go for recourse, whether that be local, state, or federal resources.
I understand now.
Okay. I have a few questions that relate to something else. Mr. Attorney, is there a legal definition of racism?
Of racism?
Yes.
I've only focused on race discrimination, so I don't know if there's a specific legally accepted definition of racism.
Okay. Has the city of Charlotte or the city council taken any position on the criminal legal system of the state of North Carolina and or the United States of America?
In terms of whether it's racist?
Have we taken any position? Have we acknowledged any, whether we like it, we hate it, is it fair or unfair?
I feel like I've heard conversations over the course of time, but I don't know that you've taken an action as a body speaking to the criminal justice system.
So more specifically, is it the position of the city of Charlotte or the city council that the criminal legal system of the state of North Carolina and the United States of America is fair and equitable?
I don't know that the council has formally adopted a resolution or a position on that.
So is it the position of the city of Charlotte that the legal systems of both the state of North Carolina and the United States of America are fair and equitable?
Again, I don't know that this body has taken a formal or issued a formal statement in that regard.
So it is it the position of the city of Charlotte or the city council that the criminal legal system of the state of North Carolina and or the United States of America is racist?
I don't know that this body has taken a position on that.
Okay. Mr. Baker can answer this, or I direct this question to both Mr. Baker and Mr. Jones. Over the past several years, have you or any of us that are employed by the city of Charlotte acknowledged the existence of structural or systemic racial discrimination in the laws and policies of the city of Charlotte, the state of North Carolina, and or the United States of America?
Speaking for myself, I've not taken an official position as city attorney of Charlotte on any of those. I have my own personal opinions, but not as city attorney of Charlotte. No, I've not made any statements.
Thank you. And Mr. Jones, Mr. Jones has been here a couple more years, and we've probably been part of a few more community conversations with different types of contexts around structural racism, especially after the Opportunity Task Force report was released in the Chetty study. So I guess I'll repeat it, Mr. Manager. Over the past several years, have you or any of us that are employed by the city of Charlotte acknowledged the existence of structural and systemic racial discrimination in the laws and policies of the city of Charlotte, the state of North Carolina, and or the United States of America?
So, Council Member Winston, much like the city attorney, I would say no. I will say that, as you are aware, the Leading on Opportunity report, which I believe that came out in maybe 2015, lays out some of the issues that I believe you're speaking to.
Mr. Winston, I know, I just wondered if you could help us understand where we're going.
I'll get there when my line of questioning is done. So what I heard is no. So does that mean the city of Charlotte denies the existence of structural and systemic racism or discrimination of protected classes in the laws and policies of the city of Charlotte, the state of North Carolina, and or the United States of America?
Who are you directing the question to, Mr.
Mr. Jones and Mr. Baker.
I would simply say that I'm not aware that the city council has spoken as a body on this issue.
Correct.
Mr. Jones?
I agree.
Mr. Baker, are there specific state and or federal laws that allow employers to discriminate against employing peoples whose debt to society is adjudicated and sentence is fully completed? Are they allowed to, certain bodies legally allowed to discriminate against employment of those people?
Taking your question literally, I have not seen the inclusion of a debt to society prohibition in any of the federal employment opportunity laws. As I mentioned to Ms. Johnson, I have seen situations where the inconsistent application of certain standards and procedures based on criminal behavior, criminal background, could actually create a valid discrimination claim. But in terms of just a general blanket prohibition against employers in that regard, I've not seen that, no.
Well, let me ask it a different way. Are there certain jobs that people are legally barred from if they have been convicted of certain crimes, even after their sentences have been fully adjudicated and completed?
Yeah, my understanding, I believe, is that for certain law enforcement agencies, there may be some criminal prohibitions, if you will, of becoming a police officer. For instance, if you have a certain criminal background, I know there's an extensive process to be certified with the North Carolina Bar Association and to get the bar license that is dependent upon your criminal background. And also, I have seen situations where attorneys have been disbarred for criminal activity. I would imagine that there are more professions beyond just law enforcement and the attorneys for that.
Are you unaware of any financial service sector jobs that people who are convicted of certain crimes are unable to attain even after they complete their sentences?
I have seen situations where the handling of money, directly or indirectly, and the commission of a crime of, say, embezzlement or some sort of financial miscalculation or what have you has been used as a basis for not allowing that person in that particular position of trust.
Okay, so that sounds like a yes. Are there specific state and or federal laws that allow landlords to participate in similar discriminations against people even after their sentences have been fully adjudicated and completed?
I am aware that landlords typically do criminal background checks, and based on what's in those background checks could be a basis for denying housing in that particular contract. Yes.
So, are there specific? Yeah, you answered you answered a different question. You answered a question about whether or not landlords practice that. But are there any specific laws, whether either state or federal, that allow the discrimination of a person from obtaining housing based on their prior conviction?
Mr. Winston, the subject matter that we have on the agenda today is the non-discrimination ordinance. And I hear you asking the attorney and the manager questions about law in general that deny certain rights. And I wondered if you could help us by focusing on what you...
I like him if he can answer the last question, whether or not there are laws on the books that allow discrimination, because this is a non-discrimination ordinance. I'm asking about, and I will connect it to protected classes here in a second, but I'm literally asking about the laws on the books that allow discrimination and or protected classes. So I think it's completely germane to the subject at hand.
So my experience is that laws typically prohibit activity as opposed to allowing activity, and I've not seen laws that prohibit the consideration of criminal backgrounds in those areas.
All right. So I would posit that the legal system of both the state of North Carolina and the United States of America is a proxy for de jure discriminatory laws and policies. Nowhere is that more clear than the ability for people to find housing after they have been convicted of a crime. While we are all subject to the effects of the criminal legal system, there is no question that it disproportionately targets and negatively affects Black people. The City Council, I believe, should adopt a resolution that acknowledges the de facto racist systems of the North Carolina and United States legal systems. The Council should resolve that using a person's interaction with the legal systems of North Carolina and the United States to discriminate against housing individuals who would otherwise be eligible to be rented or sold a place or sold a place to live. If this body acknowledges the existence of the violation of rights of protected people, then we have the mandate and duty to protect our citizens. I think that is the bridge that we can get to, that acknowledges similarly to how we are, how the discrimination around hair, natural hair, relates to race. I think that's how we get there, to make sure that people who have paid their debt to society cannot be discriminated against when it comes to housing. We know that this is an issue. We know that this is a problem. And we know that although this body has yet to acknowledge it, that the criminal justice system is being used as a de facto racist policy in this state and this country. And if we're going to do this, I say we do this with as much force as possible. I talked to Mr. Baker about this earlier. This is not changing the ordinance. This would not be doing anything to the ordinance. We have the power to protect protected classes of people. We're not expanding, as Mr. Baker will say over and over again, we are not expanding the definition of what of people who we protect, as Mr. Bakari suggested we do. He suggested that we create a new class of protected people and from their political persuasion. That's not something I think we should do. But if we acknowledge and categorize people that are affected by the system, by a racist system, as being protected, that gives us the mandate and duty to find ways to protect them using this non-discrimination ordinance. And I would be happy to work with Mr. Baker to figure out the proper language to do so by this Thursday.
Mr. Winston, this is an issue that I care deeply about, because I do believe that reentry is the most difficult situation that people can have. I would like to ask you to consider doing some work around it that doesn't delay the non-discrimination ordinance. And I tell you why, because this is something, because I've worked on it. The federal government, how many people do we have that live in the, with vouchers in this community? How many of those folks live on federal property, in public housing under Enlivian? The federal government will not allow for reentry into their units. We'd be creating something that would create two different groups of people that need housing, and I understand where you're going. And I think that this is something that we ought to get behind in a way that is addressed for everybody in this city. And I believe that it is something that we ought to research, look at, and determine where the best decision that's going to be made, or the best way to legislate this and how to do it. So while I have great appreciation for the questioning and a great appreciation for what it does for people and how it harms us, but I do believe that doing it as a part of this action would create, I think, even a greater disparity among people in this community with vouchers and that live in existing federal housing. So just the thought.
Just to be clear, I'm not suggesting including this as part of the NDO. I'm not suggesting that we delay the NDO. What I suggested is that we create a separate resolution around acknowledging the de facto racist system that the state of North Carolina's criminal legal system is, and the United States of America's legal system is, and therefore that is the bridge that would give us the mandate under our NDO to enforce that non-discrimination of a protected class.
I think that is a fair thing to do, and I would hope that if you would take the time to work on it and do some research on it, that would be something that we could have brought forward in one of our additional strategy sessions or times that we have the opportunity to talk about what we are trying to do legislatively, because it will take not just the non-discrimination ordinance, it will take a lot more to balance out what I think could create a unintended consequence. So I would like to ask that we think about that, get some research done on it, and then come back and figure out what can we actually manage, or what do we choose to manage. Is that fair, Mr. Winston?
Yes, ma'am, absolutely.
All right, thank you. All right, now, did you cover everything else that you wanted to address? Thank you. All right, the next, I have Mr. Graham, and before we go back around, we have had everyone speak, and we need to get to some of these other issues that we've outlined. I've got about 12 items that we need to give the attorney some guidance on, so we probably will be talking about your questions again, but let's try to get Mr. Graham in, and then go back to those areas that we're seeking guidance for next week. We have made a commitment, and commitments can be broken, but we did say, and we're striving towards an August 9th date for this ordinance that we have on the agenda tonight, And if the council chooses to change that date, we need to do that now, and that's why I think it's so important for us to go back and address the issues that were raised so that we can give the attorney some guidance. So with that, I'm going to recognize Mr. Graham, and then we'll go back to the issues. Ms. Johnson, Mr. Graham was next.
Earlier, we were able to elaborate on on Matt's question, so I wanted to ask Mr. Winston a question, if that's okay.
Sure.
Thank you. Mr. Winston, I wanted to ask you to clarify what that you would be requesting as far as the resolution and how that would impact the NDO. Are you seeking like a proclamation or a resolution, and how does that impact this current?
So it would not affect the NDO. The NDO allows us, and by state law allows us, and federal law allows us to protect protected classes of people. And that is what the NDO does. I'm not suggesting that we do anything to the NDO itself. What I'm asking us as a city council to consider is to consider taking a position, a resolution on the legal justice system of North Carolina and United States of America. I posit that
Mr. Winston, I think you've answered that it's a resolution that he would like to have us on the issue of the legal justice system of the state of North Carolina and the country. I think that was
Mr. Winston, let's talk offline and see where the political will is, because we know that this, their reentry and source of income and all of that is in committee. We know that this issue's been kicked down the can for a long time. So I'm happy to talk to you about that, to see if this council does have the will to do more than a proclamation for so many of our vulnerable citizens in the city. Thank you.
Yes, ma'am, we can talk offline and work together on that.
All right. Mr. Graham, you're recognized.
Thank you, Madam Mayor, and I won't be long. I just want to go on record as supporting the non-discrimination ordinance. I want to thank the city attorney, Councilmember Elliston, and the Mayor Pro Tem for helping us lead the charge on it. Racism, hatred, discrimination in all forms is not in the best interest of any civil society, and I think this ordinance narrowly tailored demonstrates that here in Charlotte that we want to put reasonable guidelines, reasonable parameters that impact those type of situations. I am willing to have a further conversation with Council Member Newton on the 3 areas that he brought up, which was, I think, broadening the protection for all, fines and penalties, and additional penalties for housing discrimination. I think those were the 3 that he brought up. I just caution the council that we ought to have a narrowly tailored approach, that we ought not to be concerned about any potential future litigation. We're the 15th largest city in the country, and doing this type of work may be just the cost of doing business. So I look forward to further discussion. Thank you.
All right. So Mr. Bakari and Mr. Driggs had a question, so I'm going to ask them to state their question, and then we'll go ahead and begin the issues discussion so that we'll have time, so that you have time to be ready to address their question. It will be at the end of those questions and issues that we brought up. Mr. Bakari, what's your question?
It's just a clarification. I want to make sure I heard the city attorney correctly. So I think you said that housing is granted to us by the General Assembly under our charter, and our charter grants sex and race under that and what we can regulate. I just want to make sure I understand, because I thought I heard 2 things. On one side, I thought you said that in the order to add sexual orientation and gender identity and natural hair, we have to go back to the General Assembly to change the charter because those areas are above what's currently allowed. But then also in another context, I thought you said that we can interpret sex and race under our Housing Act to incorporate sexual orientation, gender identity, and natural hair. So
I understand.
You understand what I'm saying?
Yeah,
okay.
absolutely.
All right, we'll come back to you with the answer. Mr. Driggs, what was your question? I see you, Mr. Eggleston. Mr. Driggs? Do you have a question? I've lost Mr. Driggs. Okay, Mr. Eggleston.
Yeah, thank you, Mayor. I know this is not what you're implying, but I think people will grab on to something that was said a moment ago about commitments can be broken. They can. I don't think this one should be, and I don't think you were implying that we should, but I think if this meeting needs to be as long as it needs to be, or council members have to do extra work this week to get on the same page, the commitment on the August 9th is something I very much think we need to fulfill. And I don't see any reason, given how much agreement there is on the core of this ordinance, why we could not adopt it on August 9th. Mr. Winston and others have brought up points that I think can and should be addressed, but can be done so outside of the scope of what we're working on here.
Well, thank you, Mr. Eggleston. I agree with you. I didn't mean that commitments should be broken. What I really meant was to get it right and to do it with the council's giving enough guidance to the attorney. I don't want the community to have an ordinance that's significantly different from what will go out on Thursday without the discussion by this group, which is why I'm going to now go to the discussion first on the private sector being included in the ordinance. I think this was Mr. Newton's first question. We have it so that what the city attorney recommended is because federal law covers over 15 and the city's ordinance would cover under 15, and it was just a question of redundancy. But I think philosophically, some people were saying it's actually an additional opportunity. So council members, if you have some thoughts about this, it would certainly be helpful now to express your ideas. I think we've heard the arguments from Mr. Newton, and he's asked for your comments about this. And I'm just looking to see if anyone has given it some thought. All right, so we'll leave that one. Mr. Graham.
So I'm hearing you say that you would want to have to apply for employees under 15 and below?
So it's something that would be broadly, what I'm suggesting, and to be clear, I will be supportive of this ordinance on Monday because I think it's so important that we do this. And I think that there is so much substance in what we have in front of us today that needs to pass. Having said that, this is certainly something that I would prefer us to look at and consider. The idea that we expand protections beyond just 15 and less employees to all employers. So we effectively fill the gap, that exists for 15 and below and provide an additional option to combat discrimination within our city. State and federal remedies can be difficult to pursue. They can be complicated and complex. They can be more costly. And us instituting a measure within our ordinance could be an option that could be pursued by folks that don't have that expense, that time, that ability to pursue state and federal remedies. This would be an option that may be simpler, more effective, and less costly. That's what I'm asking us to consider, expanding it for the sake of creating that additional option.
Can I respond to Mr. Newton?
Yes, Mr. Winston, and yes, Mr. Winston.
Mr. Newton, I feel like this is something that I often try to see that we can be the place to provide services, even if this is something that, for instance, the city attorney wouldn't handle. Maybe we act as a clearinghouse to help help folks through that very convoluted and complicated process. So perhaps maybe this isn't something that exists within the non-discrimination ordinance, but maybe this is something that we work with CRC to say, hey, is there an office that people that are part of larger corporations can come to within the city that can help facilitate some of those more complicated state and federal processes to at least get them started on the right direction. It seems like what I'm saying is this seems like This might be a budgetary thing. It might be a staff thing that is part of our non-discrimination efforts, but isn't something that lives in the ordinance. Does that make sense?
And I'm on board with that too. I wonder if that would actually be more expensive than us just expanding this and using the existing process that's already in place through our CRC and by virtue of this ordinance, an enforcement remedy through our city attorney. Why not just take that route? But I'm on board with that too. I'm not saying, not to explore any and all options, that could be at our disposal and exclude any possibilities. That works for me as well.
So let's try to get the feedback from the council members and then go back to see where we are. Ms. Watlington?
Just had a process question where I was wondering, were we doing some kind of straw votes or?
Can't hear you.
I said I was just wondering from a process standpoint, were you wanting us to do some kind of straw votes, or how are we supposed to register our concurrence, or if we didn't have an issue, is the intent that before the night is over, these 12 items you've got listed, we've got clear direction to the attorney, or are these just kind of still taking comments?
Well, this is how I've looked at it. I know there have been some questions about the straw vote and the process and whether that's a valid way to look at this. But at the same time, what I look at and what I was trying to glean was how many people are actually reacting and commenting, and it does, and offering a yes or a positive statement around it. That's what I was hoping. But if you would prefer the straw votes process, that's certainly something we can consider. This is about the council getting an ordinance for next week. So whatever process looks, as we're working through this, it's workable. What makes it work for you best is what I would like to do.
Okay, I'm not partial to either one necessarily. I just wanted to, if we're not doing any kind of like formal vote, I just wanted to lift up our +1, if you will. I have no issue with including the housing piece in this ordinance, even if it comes off redundant, if you will. I also have no issue extending to all employers either. So I just wanted to put those two there. You can add my name to support for those.
All right. All right. I don't have anyone else that signed up to speak. The next issue that I think Mr. Newton brought up was fines and increasing fines along with the injunctive relief. Did I say that correctly, Mr. Newton?
Yes, ma'am. And so basically, it's just us creating the most significant deterrent possible to combat and prevent the forms of discrimination that are codified within the ordinance. Certainly, I think that conciliation and injunctive relief can be effective, but I think it's also possibly more effective if we have conciliation and injunctive relief alongside fines.
I also would say that Mr. Driggs has suggested that this is something that's going to be new and different if we include all employers. I wonder, Mr. Newton, if it would be appropriate to look at a year, 18 months, to see what's going on before we decide to change something that's been on the books that people understand readily. I understand what you're saying, but I think that we need to probably get something under some data that would allow us to see where it works and where those relief things are not working, or are the cases being followed. We may not have to do that, but that would be my thought, is that this is something new, and especially as we're doing it for small businesses, if the council is going in that direction, if we should just wait a year to see where we are. Ms. Johnson.
It's my understanding that the employers with 15 or more employees have to already follow these policies, right?
Yes, they're covered under federal and state.
Federal and state. So if we added it to our ordinance, I know it could be labeled, I guess, called redundant, but is there any harm in us? What are the pros and cons of us doing that?
For me personally, I've been focused on the gap, just as your lawyer, to focus on the areas that are missing. There are potential legal arguments about, and I've seen other communities that have gotten into the 15 and above range. There are potential arguments for whether or not that's a proper place for local government, because we haven't done it in North Carolina. I've seen it in other states where other communities have, they have their own local. I think the city of Phoenix has one that's local, that has the same classes, but applies to all employees within their jurisdiction. So with this, a little bit of uncertainty in terms of whether we can get involved in these areas or not, I've really just been focusing on the gap piece, because now you're talking about an entire new class of employers that we're potentially now investigating for employment discrimination, things that are already on the books now for the federal and state governments to handle.
Okay. One of the things that we might do, Madam Mayor, is hear from our public. We're going to hear from them next week, so maybe this is an issue we don't decide today, but most things we need to hear from our public, what's going on outside this room. So this is an issue that there doesn't feel like there would be any harm in adding that to the ordinance, especially if they're already covered under federal and state. Many of these issues, we need to hear from the public. They've heard the discussion. Maybe these 12 items or whatever items we decide on, not try to make a decision tonight.
Well, we're not making the decision tonight. I'm just giving the attorney an ordinance to send out that would be visible for the public, and then they can come in and bring back any idea that all the way across.
Okay.
There are probably going to be a lot of other suggestions made. No way are we limiting that meeting.
Right.
So as I've told people, 11:30 sounds like a good time to end that meeting on the 9th. So,
well, I would support this in the local ordinance also.
okay, I think you and Ms. Watlington have said that now. So I'm going to go and make sure that we've gotten that. So that is one that you've seen some support for, but also Mr. Newton has said, I can live with what we've got in this ordinance. If I said that correctly, you did say you could live with it. Yeah, so, but then the question
For the
was
changes, but yes.
around the fines, and I'm asking Mr. Newton, can you live with the idea of coming back and doing the data? Because you can always correct the changes in the fines and injunctions, but we don't have any data right now, and I think it would be something that could impact what we would do based upon what experience we have.
I feel like I could live with it, even though I would hate to find us in a situation where we could have prevented discrimination sooner, or alternatively prevented it altogether, just by having, once again, the most significant deterrent possible to do so. I loved Councilwoman Watlington's idea of straw votes too, by the way, where we could really just cut to the chase on many of these as quickly as possible to give the city attorney the direction he needs to put something together, so we're not delaying this any longer.
Oh, I'm fine with that. I think, so it has been, unless someone objects, we'll do straw votes on each of these after we're done. Does anyone on the council, Mr. Winston, do you object to that? I have Mr. Winston next. Do you object to having straw votes on these items?
No.
Okay. All right. So, Ms. Isold and Mr. Phipps.
Yeah, I just have a question for, in practice, how something would work. If we voted to include an increased fine, a clause that increases our fines, but then we've also included employers over 15, and we have, let's say, a large employer that somebody brings a complaint against, and it goes to the CRC, and they don't show up, and they say, no, we'll take it up with the EEOC. We don't have to answer to you, City of Charlotte, and then we start imposing these fines, and they're not, their legal department's bigger than our legal department. I'm just wondering how that really plays out if we do both of those things at the same time, yet we don't really have the authority to compel a large corporation to comply with what we've passed. Can you talk about that, Patrick?
So, again, when conciliation fails, and that could be early on in the process where the employer, again, we haven't done this before, but if the employer decides, you know what, I don't recognize the city ordinance anyway, and I'm not going to be bothered with it, they can take me to federal court with the EEOC or what have you. Then we're left with, a referral back as written to the city attorney to determine what appropriate relief is available. And again, we just haven't seen a situation where the CRC doesn't even get the opportunity to do a review. Now, it's quite possible that the city, we could be hauled down to the courthouse as well for an injunction, basically saying that our ordinance is not valid if that's what they wanted to do. It's really hard to see how it's going to play out. Either just ignoring us or potentially just going straight down to court and challenging our authority to have the ordinance in the first place. But it would, we'd have to see how it went out, because I just, we don't have that on the books right now. I wish I could have a more definitive answer, but this is all brand new if you go down this road.
Ms. Johnson?
Do you have any guidance? I know that when you were researching, you focused on the gaps, but now that we're here tonight, do you have any guidance for us?
Guidance in terms of?
If we should add it into the ordinance or not?
I would like to, so we recognize that there's a gap, and my preference legally would be to focus on the gap first to see if we can address that. And if it appears that we need to go above and into the areas where the federal and state laws exist, then we look at that as we go further down the road, because we've never done this before. I will say that, and I won't use a particular employer, but picture a major employer in Charlotte, and an individual decides, you know what, I'm going to go to the city ordinance for discrimination, forget the federal and state, because I don't want to hire an attorney, and I don't want to go through that process. I want to go straight to the city, and I want Mr. Ratchford's group to do an investigation of a major employer. Again, as the mayor said, may have more lawyers in their department than we do. I mean, I could see a situation where we're significantly burdened trying to get all this information. We don't have the ability, as exists under EEOC law, of certainly, subpoenas, bringing folks in and forcing them to comply. We've just got an ordinance and an untested ordinance at that. That's why my preference would be to start lower with that group, because we know that that's a group that has been unprotected throughout the process of these discrimination claims, and then see whether we've got the ability to handle these complaints, investigate the complaints, and build up, because we have no bench whatsoever right now to effectively become our own EEOC department going forward.
Okay, so I'm going to come back. Mr. Newton suggested that we do straw votes. And what I'd like to do is start off with the straw vote of the recommendation that the city attorney has made and presented today, to say, would you support the ordinance as drafted to be on the agenda for on August the 9th? And Mr. Eggleston has asked to be recognized. Mr. Eggleston. And I want you to consider, this is a straw vote on acceptance of the draft. I think then the city attorney would provide answers and rationale to the questions that you have raised as information. And that way the council, not only the council, but the community would have answers to the questions, and perhaps a little bit more than on the feet reaction that he's having to do right now to some of the suggestions. I thought that most of you had an opportunity to talk with him about these in a little bit more detail, but I also understand that that's a hard thing to do when it's on our break month, and so we can try to figure this out. But I would like to say that we should take a straw vote on the ordinance as submitted this afternoon, and have the city attorney address those amendments and those that he would recommend, I guess in conjunction with the CRC and the impact of doing those of the list that we have, and we can just make sure that we have a complete list. All right, Mr. Eggleston?
Thank you, Mayor. And I guess I need to clarify and make sure I'm understanding. I am in support of us taking a vote on the ordinance as we've got it next Monday, but I do think there's something, and I'll give everybody the benefit of the doubt because I believe to a person, everyone has had conversations, in most cases, multiple conversations with Mr. Baker. What we might not have had a chance to do is all talk with every other council member to see where there's agreement and disagreement on certain things we might have discussed with Mr. Baker. So I think that's a fair discussion to have tonight. I think some good points have been raised, some of which, if we were to straw vote on individually, I'd have a hard time being a yes or a no, because I'd be a yes if the question was, is this something we think has some merit and deserves additional research and consideration? I'd be a yes. If it were something that we were saying we wanted to try to tack onto this ordinance in short order, or something we wanted to tack onto this ordinance, which would delay the vote on this ordinance, then I'd be a no. So I'd like to see us move forward with the ordinance as is. If there's some tweaks that need to be made to the pieces that are and elements that are already there, I think that's fair game for discussion tonight and any day between now and hopefully Thursday. I think we ought to have this put to bed so that the public can see specifically what we're voting on. But some of these other things I do think are things worth exploring. I just think they should be done separate and apart from this non-discrimination ordinance. So happy to dig into any of those other things, but would like to see us move forward with what we've got so that we can get it in place as quickly as possible.
Mr. Eggleston, you said that very well. I guess what I was saying is giving the city attorney the opportunity to give the council a specific list of what has been discussed so that it can be distributed. And if even, as Ms. Johnson's point, is that citizens can come in and say, well, this is something that we want to do and this is what, how we see it. But there would be the ordinance, if the council agrees, that Mr. Baker has submitted tonight. And then there would be a list of those requests that have been made by the council members, and there can be further discussion, but that list could be available for the citizens to review as well as the council members to review. And at that point, on the 9th, we would actually have, you'd have to have 6 votes to get it placed into the ordinance. So does that make sense?
I would be a little weary of amendments to the ordinance on the 9th. I think that could get tricky. I mean, I guess if we had the potential amendments spelled out in advance, but I think if we're trying to wordsmith from the dais on the 9th, we're setting ourselves up for failure. So I would think whatever.
I was hopeful that the city attorney would make recommendations and that they would either be accepted or modified, but I would hope that it would not be wordsmithing the document. I think what we've had is a list of topics that people have suggested specifically, small business, religious exemptions, things like that. But this is something that it's very important to get done, and we understand that. We are impacting people's lives.
I would be supportive, and maybe I'm the only one in this space, but I would be supportive of exploring it. But I think it's going to take more than the week that we have. So, to me, if there were some of the folks who have brought these forward were to say tonight, yes, this probably requires more than a week's worth of work. I would be supportive tonight of saying, then yes, let's commit to doing that work. But if on Monday it was put forward as an amendment to potentially add into the ordinance, I'm not sure we would have done the due diligence that those issues deserve.
All right. Mayor Pro Tem was next, followed by Mr. Phipps and then Mr. Bakari.
So my comments were similar to Mr. Eggleston's, but I feel like if we could get exact language by August 5th that every council member could look at, I, for one, would be willing to look at, the ordinance as it is, but then substitute motions to add those additional things. But we have to have that language. I've said it before, I can't process on the fly like that. I can't look at language and then decide in the moment that I would vote for it on something that's so consequential. So, if there was an agreement on council that we could get this language from the legal department by August 5th, and we knew what we were going into with those additional amendments, then I would support it. I could be in a position to support or oppose a substitute motion. But I do think, for instance, if we increase the fines, I guess what I was trying to say, along with including all employers, that might change the way I vote with including all employers, just because of the enforceability of it. So whatever we do, I just think we need to know this by August 5th, and that the language is out there, and we go into Monday night knowing exactly what we're going to do and what we're going to vote on.
So, Ms. Heisler, I think you were suggesting that, along with Mr. Eggleston, that we use the draft that came to us for tonight and then make a decision later, following the 9th, if I heard, the discussion of the additional items that were added, unless the council as a group could come to some agreement over the next several days. And that would really basically be where you have decided to make a substitute motion that your colleagues would support. Am I saying that correctly?
Yeah, so we agree on this base document, and with any additions that we get that language, we have the conversation with each other, but when we go to vote on it as substitute motions or additions, we know what the language is. And I just asked my colleagues if we would refrain from doing it, coming up with that language on the fly the night that we're going to expect to vote on it.
Let me check with Mr. Baker to see, after all of this list today of the comments, and I think we've had everyone ample opportunity that you could check with them. I know Ms. James has also been writing furiously, that you could actually say, this is what I heard, and get something out to council members tomorrow, that this was the change that I requested.
Yeah, and I don't know if this will help or not. There are some key items that would be helpful for me, and I think would be helpful for you, big items that we can sort of check off. And if we're talking about on the 9th, kind of working around the edges, that's fine. But I've proposed a protected class that has all of the elements there, and I would say it would be really helpful to me if council could either agree to accept the protected class as I put out there, or if you want to add elements to the protected class or subtract, that would be one that I could just push aside. I don't have to worry about that one anymore. Do you want to get into the employment discrimination realm, yes or no, as to whether or not you want to adopt an employment discrimination policy? If yes, then what's the group that I'm looking at? Am I looking at 14 and below? Am I looking at everybody? I think those are the two main choices, is whether or not we want to go with the smaller group or have that policy apply to every employer within the city. The third thing for me, and we've been struggling with this, is the way to identify and articulate the protection for religious liberty that exists in law right now. I put some language out there that I've tried to make clear. Basically, if we're going to do employment discrimination as a unit, City of Charlotte, that we should be following established federal EEO law, including any changes in the law that occurs. That should be so that it shouldn't be, sex discrimination shouldn't be one thing in Charlotte and a completely different thing in another community in North Carolina. We're all following EEO laws, and it would be helpful to have some language that we can agree on to adequately protect those exemptions that exist already at federal law, to codify them into here. I've tried to have a blanket language so that we don't have to argue over, maybe argue is not the right word, but discuss every single potential exemption that, again, as case law gets developed, the case law could change. I'm just basically saying whatever your defenses are and requirements are at the federal EEO laws would be your defenses and requirements with the city of Charlotte. Those items would be really helpful for me, and then I think that leaves you sort of clipping around the edges going forward. But I can tell you that's where I spent the majority of our time trying to define that protected class and then address this employment piece.
Okay, you've heard the city attorney say that these were 3 issues that he would like some guidance on from the draft that he has proposed tonight, and they are protected class definition as he has written it here. Employment discrimination, is it for 14 and below or for all? And then third, identifying, and Patrick, can you cite the section where the religious liberty?
So I've included it in section 1231. It's on page 4. And basically what I'm trying to say is that there's nothing in our ordinances that creates a unique requirement that doesn't exist under federal and state law. And I have specifically stated, in fact, that section ends with this includes but is not limited to applicable legal exemptions for religious organizations. I'm just trying to make sure that the community understands that we're not doing something brand new here, except for the fact that we're doing employment discrimination, but the actual discrimination isn't something unique to Charlotte that doesn't exist if they went to the federal courthouse. It's going to be the same case law that we're going to be looking at. So there's some consistency for employers to be able to rely on.
So what I'm going to repeat those 3 things, and what you have done in the draft that you submitted is to recognize where federal law and state law is covered and acknowledge that without repeating it.
Right.
But also making sure that it's applicable.
Correct.
Okay. All right. Is there anyone that would like to comment about anyone? Let's start off with protected class. Well, let me start off with this way. Is that acceptable to the group to have the process that the attorney needs the 3 steps for guidance on by a straw vote, and then to have the other items explained in a memo that would come out with the agenda item on Thursday, by which the council members would engage and see if there would be the opportunity for a substitute motion, I believe, or a motion to amend, or it would be an amendment to amend what would be the draft. Okay? Does that make sense? You're saying it doesn't make sense, or you don't agree with it? Oh, that's okay. That's fine not to agree with it. I'm just trying to make sure that it makes sense right now. Ms. Johnson? I see you, Ms. McCarthy.
Some of the items that we're talking about are included in those 3 highlights.
Yes, they are.
We cannot hear Ms. Johnson.
Okay. So if we're not able to decide that, maybe we should include all of the items on the memo, and then we talk about them.
Well, let's see how far we get.
Okay.
Okay, that might be better. Let's take step one and see if we can get there. Mr. Bakari.
Yeah, I'm just a little confused because, we have brought forth from the Republican side a baked version, legally vetted and communicated across the state almost 2 months ago, where we had no dialogue, no discussions, and then a week ago, we saw the first wording that I've ever seen and that the public has ever seen, and now we're talking about, well, we have the last minute jam through, and we don't want people adding wording on the fly, and I feel like we're about to do some sleight of hand here where we're not going to get an opportunity of adding in several more things, other things that we have crafted have found their way in here, some things have not. And these are very important things around religious protections, around the natural hair and pieces of employment over 15 that aren't included and covered. There is a gap there that exists. Around housing, there is a gap there. And then around political affiliation, where there is discrimination going on. So I would personally say we've put 8 months of work into this. At a minimum, I would hope that since there's some mad rush now for this all to be passed and us not to slow the process down when we've been waiting for months, we at least do a straw vote on the 4 things that this version is not as strong as the Young Republican version that has been vetted and in the public for months now.
So what would be those 4 things, Mr. Bakari?
1, that the city contract piece be taken out because of the small business burden that puts on and the inability for small businesses to follow that. 2, the pieces that I mentioned around employment being over 15 and included, and housing, because there is a gap. One example being
employment over 15?
employment over 15 and housing, because the gap exists, for one example, with natural hair. Like I stated earlier, our version of that, the wording that is public and out there, we don't have to figure something net new out. That just has to be incorporated. 3, the religious protections that, again, show deference to not infringing on the individual liberties of other individuals or organizations. And 4, the addition of political affiliation and actions.
All right,
So
thank you.
I'd like those straw votes if we can't
If we're
summarize
going
and
to do
talk
them.
about them.
All right. Mr. Phipps?
Yes, thank you, Mayor. Is it conceivable that at the public hearing that we would receive more comments that should have due consideration, deliberation by us in the same manner that we're doing that we're undertaking with this exercise tonight? It seems like we are foreclosing those comments already before we even hear them and rushing to vote, have the public hearing and the vote on the same night. So what do we do with the comments that are given to us in good faith by the public?
Yes.
That's what I'm concerned about and confused about.
Mr. Phipps, I think that, you know me well enough to know that our agendas go out on Thursday. People can sign up to speak on any agenda item. We don't generally send out a preview except through this type of meeting, which is what we're trying to do now. And if the council doesn't agree that they have sufficient information or agreement on an ordinance, then you can say it will be delayed. I don't think that we're saying that, the public comes down and speaks on these items often, and then there's a vote. But if you do not feel like you can incorporate those changes that you hear from the community, then we would have a motion. I would expect someone would make a motion to defer until you have time to incorporate those things from the community.
But it would seem to me that we're jumping to the conclusion right now that the vote would occur regardless of what the public would say on it. So that's what I'm trying to come to grips with.
Well, we have told and said, as to Mr. Eggleston's point, we have been talking about this for, I think, several weeks, and that we did say that we would have a vote on August the 9th and that we would have this process. I think I talked with everyone except Mr. Bakari, that we would have this meeting and then we would have it on the agenda. So that's where we are, but this is I'm just going to say this. This is so important that we need to get it right. And if the council feels like it's not right, then we keep working on it. That's basically all of our items are that way. And we've had some tough items, and we've worked through them until we got to a place where it was time to vote. And so when in this case, I think that we can either do, as I suggested, the first one was to accept the draft from the city attorney and then have him get the guidance on those 3 items. Then if those are not consistent, or if those are approved, he would draft the ordinance in the way that incorporates those 3. And he would also send out the list of those things that were questions that would go out tomorrow, and his responses to those questions would go out on Thursday, and I think he's agreed to do that. So that's option 1. The second option would be to do that very same thing and then vote on a straw vote that Mr. Bakari has suggested, taking out the city contracting, including the employment and housing discrimination, and changing the wording on the religious protection. So that would be the second option. Does everybody understand those two options? All right, so I'm going to ask, we definitely have to have the city attorney prepared, so I'm going to ask for raising your hand on the protected class definition as incorporated in the draft ordinance that everyone received in their packet today. All right, if you just raise your hands.
Can I ask a question?
I have Mr. Newton.
Can I ask a question about that?
Let me just count this vote and we'll come back. Mr. Newton, Mr. Graham, Mr. Eggleston, Ms. Iselt, did I see Mr. Winston, Ms. Watlington, and Mr. Winston? So that's 6 folks that would support that effort of the protected classes. Okay? All right, Mr. Phipps?
Yeah, I was going to vote on it, but I wanted to get clarification on whether or not we were going to put them in parentheses based on the primary protected class category, like sex in parentheses, we would have
to include sexual orientation,
right.
Yes.
Yes.
Yeah.
That was the, I think in the draft that you have, it would be as stated in the draft that you have.
Well, I would be a yes vote for that.
All right, so Mr. Phipps is also a yes on that, and that's 7 people that support that. All right, Ms. Johnson?
I also wanted to speak with Mr. Winston prior to, well, I know this is not the actual vote, because I think there might be an opportunity to discuss including individuals with criminal background, or would that be parenthetical to race? So of course I'm going to support this group, but if there are is an additional class that we are able to add parenthetically or directly, I'd like to at least be able to discuss that.
I think that we were going to try to figure out what the reentry definition was with a position paper. I think that's what, when I spoke with Mr. Newton video, to actually get some research on what that is. That's
Right.
what I thought we were doing.
Right, and I still like the idea of getting some more information before we're actually making decisions, like if you could get something to us by the 5th, and it gives council time to review and look at things in writing, rather than just discussing this.
Okay, but let me be clear. It would not include the reentry research on Thursday. That was beyond what we were trying to do for this ordinance, but it would be later. Is that what your understanding was, Mr. Winston?
Yes, ma'am.
So, Ms. Johnson, is that okay with you? Okay, I just want to make sure. I don't want to walk out without us knowing an agreement. The 14 and under for employment
strengthening workers' position. I think we need to understand what is written here and what Mr. Baker is proposing. Now, this is something new, and I think he wouldn't propose anything that he isn't confident that he can defend. If we go 15 and over, I think that one of the challenges is we're going to put an undue burden on him defending this, because we will be providing a solution that already exists. And in fact, those two solutions, those state and federal remediations to that issue supersede anything that we can do. In the absence of anything of 14 and under, I think this will give us the best chance to give all workers in Charlotte recourse should they believe that they are facing this discrimination. And I would really hope that we give our attorney the best chance to succeed as we try to do something new and cutting edge, as I'm pretty sure he'll have to defend it at some point in time. Thank you.
Okay. So for employment discrimination and including 14 and below, please raise your hand. We have Isolt, Eggleston, Watlington, Graham, Phipps, Bakari. So that is 7. All right, 7 folks in supporting that. Now, all right, I guess I should have started backwards. All, for including all. I'm sorry, Mr. Bakari?
Yeah, I would just say I don't agree at all with the
6.
last comment on the bandwidth and the ability. This is something that is very much part of the CRC process and can be adopted there and is as much as we can bite and chew off and as need to. But on the 15 and above, I just want to be clear, there is a gap there. A black woman with natural hair would be able to be fired with no recourse at a company of 15 or more people if we do not designate that. That's why it's in the Young Republican version that we have ignored to this point.
All right, Mr. Newton?
Yeah, and I agree, and I appreciate that. Of course, I'm in favor of including all employers, but I want to be clear as well that I'm also in favor, so in lieu of that, I'm in favor of 14 and below. So I didn't want my vote a second ago to be misconstrued into thinking,
No, it wasn't.
anyone thinking that I wasn't in favor of 14 and below.
Maybe let me start it this way. The restatement, would you like to include the restatement of federal and state law in our ordinance? That's probably a better way to describe this vote. Mr. Bakari has made a point that it excludes the Crown as it is.
So this straw
in a
vote would
company.
remove the size designation from our ordinance and would just say this would apply to all employers.
Correct.
Is that correct, Mr. Baker?
Yes, that's the question that would
That
be
is the
helpful for me
question.
to be answered.
So, is everybody ready? Everybody understands it? Okay.
No.
Okay.
I just need you to repeat it one more time, Madam Mayor. Thank you.
All right. So I'm going to say this, that we would include all employers in the city, 1 to however many, in the employment discrimination ordinance. We would restate that we would include the federal and the state protections in addition to those under 14. Am I stating that correctly? All right.
That's my understanding, yes.
Madam
All right.
Mayor,
Yes?
I think I heard Mr. Baker saying this, maybe if you could clarify that there would be language in there that says in accordance with existing federal and state law to point out that they are covered. I don't have a problem with stating it in there, but Mr. Baker, would you include that language in there?
In addition to the language that I already have in here?
If we're going to cover all employers, would you be stating in there that there are protections existing for state and federal, for companies over 15 and over under federal law?
Yes, to be clear, we would be using any applicable case law that's coming out of the federal EEO decisions. So it would all be the same law that's being reviewed, except we are now going to be in the employment discrimination game for employers 15 and above.
Mr. Bakari, follow that.
Federal law does not cover natural hair.
So federal law covers race discrimination. Crown Act essentially says natural hair discrimination is part and parcel of race discrimination. That's the argument that's there. But you are correct. I do not have a case that says one way or the other whether or not that's
Which
the
the
situation.
premise of the months and months of the Young Republican Working Group came with was if that was valid on the federal front, there wouldn't need to be a Crown Act currently underway working its way through the General Assembly. So we work under that premise. So that's why, again, the thoughtful approach we took for 8 months that hasn't been debated and discussed until this mad dash 1 week until it's time again, needs to be held with a little more warrant. We should have been having these conversations 2
Mr.
months ago.
Bakari, did you send a copy of that to the council
Absolutely,
members?
100%.
I did not receive a copy of your ordinance that you're referring to, so I think that it's a little bit disingenuous to
So
say.
you did not see that, Madam Mayor?
I did. I saw something on your website, and I saw 2 changes, but I did not receive an official copy as mayor to say, this is something I would like the city council to consider. Maybe I missed it. Did any other council members receive it?
Did anyone not see it?
Mr. Bakari,
Okay.
you know,
One.
can I make a comment, Madam Mayor? We've been working on this for months as well, because we're working through our legal department, and we're working, and I've called council members, and, you know, Mr. Bakari, I saw your campaign email that got sent out, but you didn't send that to council members, and I appreciate the work you're doing, and I'm fine with including that language in there. If it's covered, it's covered. Let's just clarify it. This should not be a political argument. This is about people's rights and expressing that we value the protections against discrimination for all people. This should not be a political discussion. That's the language we need in there, that's fine, but let's just move on.
I couldn't agree more.
I think that Mr. Baker is saying that the Crown Act is covered under the ordinance that he has provided for employers. Employment discrimination.
So what I have in front of you, what I'm saying is by the wording that we've used, and this is the wording that other ordinances have used, or other municipalities have used, they're essentially making the bridge that the Crown Act typically makes, which is natural hair discrimination can be part and parcel of race discrimination. I've limited it to 14. Mr. Bakari's point is that it is not so clear at 15 and above because right now the state nor EEOC has weighed in on that piece. It is possible that they may and just determine, because you can create a protected class by both statutorily doing it. You can also do it through case law as well. And I suspect that one or the other will happen.
Mr. Graham?
I support the attorney's recommendation. I hope the council will move forward with that. Thank you.
All right. So, Ms. Johnson?
As a black woman with natural hair and whose child has actually been discriminated against based on natural hair, I would want to see as much enforcement and as much reiteration of this policy as possible. So if there's a gap, and we know that there's a gap, I don't understand the debate if it only helps our citizens.
I don't know that there's an agreement that there is a gap, and maybe I should ask that question. We're saying, you said if there's a gap, is there a gap, or is it covered under racism, or is it covered, or is there a gap, Mr. Baker?
I think the answer is we don't know for sure.
Yeah.
You can make an argument, but it's not been definitively decided. That's why Councilman Bakari does have a point.
Okay. We have the 14 and below, and we have the to the all employment in this protections. Raise your Mr. Graham, Mr. Bakari.
Or saying that our ordinance applies to all.
That's what I believe the question is.
Okay.
That is the question. It's hard. This room is spread out, and Larkin, I'm like, okay, Miss.
What we're actually voting. You said including a separate thing of our.
I thought it was a statement of, but maybe.
This issue of whether or not natural hair would actually be seen as race discrimination unclear, but all the other areas of, you get the whole bucket of discrimination, not just one piece of it. You get the entire protected class now going, and areas that are this potential gap that exists with natural hair for employers 15 above is to literally say that natural hair discrimination in the city of Charlotte will apply to all employers in the city of Charlotte.
Okay. All right, so the motion is that natural hair will apply, prohibition for discrimination of the Crown will apply to all employers in the city of Charlotte. And I've got two hands. Mr. Winston asked the question first, so Mr. Winston?
Mr. Baker, in your opinion, does this language change, would it change the way you approach defending this, a challenge to this in court?
So we would only be talking about natural hair discrimination as opposed to everything else in the protected class. If you are interested in focusing on filling the gap, and there is at least a theoretical gap on natural hair above 15 and above, that this is a way to narrowly tailor it to where we're only swimming on the natural hair side, as opposed to now any race discrimination claim from the largest, or sex discrimination from the largest employers, are now going to be covered under a city ordinance.
All right, so.
And that's just a suggestion that I'm offering.
I'm going to say it back to you and Mr. Winston so that we are saying the same thing, that Mr. Baker will draft to make sure that the Crown is covered for those over 15 employees, specifically for the City of Charlotte's ordinance.
That would be for all employers in the City of Charlotte.
So all you have to do is not have the words 15 and under, right?
For natural hair.
Well, because everything else there is no gap. So you don't have to get complicated with the
That's right,
language.
we're
Just take away the 15 and under.
If everyone can agree, let's focus on theoretical actual gap, let's focus on that, then yes, it's a sentence.
All right, so we have that we are closing the gap on the natural hair for all employers in the City of Charlotte. And I have Mr. Newton and Mr. Graham, are you okay?
I'm still confused.
Okay.
Okay, so
I think he's closing a gap that Mr. Bakari has raised.
But I am in support of that, but at the same time, I would ask us not to forget to also vote on all protected classes as well. So not to kind of separate this out and then forget a consideration of all employers as it pertains to all protected classes.
We're going to vote on the closing the gap for the natural hair. The attorney understands what he's trying to accomplish. Mr. Bakari agrees with him. Mr. Graham.
So that's an amendment of your language that we're voting on?
Yes.
All right.
And that addresses this gap that we're talking about, because the EEOC has not said as of yet that natural hair discrimination is race discrimination. That has not occurred yet.
And we're amending your language?
Yes, I would add a sentence to where in the City of Charlotte, all employers who engage in natural hair discrimination would be covered under this ordinance.
All right, thank you, sir.
All right, so let's raise your hands if you're in favor of closing this gap as the city attorney would provide in the ordinance. Please raise your hands. All right, we have Mr. Graham, Ms. Johnson, Mr. Phipps, Mr. Bakari. I think that's unanimous for everyone. All right, so we're good. Now, the next item that we have.
I got a question.
Yes, I said everyone.
Okay, I got a question, though.
I'm sorry, Mr.
He has a question.
Phipps. You have a question? I'm
Yes.
sorry.
So would this apply, because you also said that this natural hair comes under race and national origin. So the national origin piece would be included too, or?
Yes, it would be included through the process. For the most part, we've seen natural hair discrimination be part of race discrimination, but I have seen some cases where natural hair is part of an individual's national origin, and that's why I provided both.
Okay. The next question, I think, has been Mr. I'm going to come back to Mr. Newton, who would like to include all protected classes under the 15 and over in the ordinance, but I'm going to finish the city attorney's list first. Identifying, the third question that the city attorney asked was identify the religious liberty, and what he has done is incorporated federal law into the draft. And I think that Mr. Bakari had made a counterpoint, and Mr. Bakari, can you restate your counterpoint?
What is the topic
The
again?
religious
Oh, okay.
protection.
So the difference between this version and the version we had put out is around clarity of religious organization and individual protections. So in the example I used earlier, a religious school, a nonprofit, an organization could be forced to go to court to ensure it doesn't need to hire someone whose actions go against their beliefs. And it's clear they wouldn't. In the end of the day, it's one of these things where we can explicitly state something like we have in our proposal and prevent people having to ultimately go to court to have that. So I think just adding those clarifications in are pretty simple, and I can give you the exact language, but it's something that has already been provided.
Mr. Baker has said that the section that he says this includes but is not limited to applicable legal exemptions for religious organizations covers that in the ordinance. Is that correct?
That was my attempt to do it in broad language, which is that pretty much that entire paragraph, just to reiterate to the community that the federal laws that would be applicable to those above 15 would be applied here as well, which would include any assertions of religious liberty and freedom that would be accepted at the federal law. And I've tried to just create a blanket statement, but I'm happy, if need be, because I think we're all on the same page of we're not trying to destroy religious freedom that doesn't exist in federal law right now. How we get there, I'm just trying to give broad, because that changes, and I expect, particularly with the Bostock case, that there are going to be cases that are going to be discerning this language. But how we get there, I'm fine with pulling that language that Mr. Bakari has put together, because I don't think that he and I are in a disagreement with what we're trying to get to. We're just, it's a word thing, but I think we can get there.
And again, and I totally agree with your sentiment. I think we are in theory and in spirit there. I think that this is another case of us very specifically stating it, because there's a lot of people from the religious community who are very concerned that they are going to be forced to agree with a perspective or forced to bake a cake against a religious view. And we are very much not trying to infringe on those liberties and protections, but we are trying to protect those from being discriminated against on the other side. So explicitly stating that is the kind of bridge building that we should be doing right now to ensure that everyone kind of walks away with this saying, okay, I understand.
Yeah.
All right, Mr. Newton.
And it sounds like this is already existing law.
Yes.
All right.
So I think the question is, I'm sorry.
Sorry, ma'am.
The question is, I think both people have accepted the theory and the substance of what's being said. The question is how many words you put in it and how is it written. And I think that's the question based upon what was in the red striking versus what's the blue striking on your document that you see that's in front of you.
There's a few other things that aren't there. There is a practical, it's not just a touchy-feely thing. There's a practical reason too, which is when we are not clear and explicit in our ordinance language, people ultimately have to go to court when something arrives and conflicts versus we can be very clear about it now. So the language that we're referring to, a religious organization, I have the language here. You've seen it before, so we can forward that over. But I think it's the theory that makes sense for right now.
I'm going to suggest then that we do understand what we're trying to do, that Mr. Baker, you work and look at the language and bring us back a draft. Okay?
And I could have that
Everybody okay with that?
to everyone by Thursday, and certainly Mr. Bakari, I'll
That's
get that
fine.
to you sooner just to make sure we're on the same page.
Okay, so those cover the three. Is everyone accepting that premise? Let me just raise your hand if you're okay with that premise. All right, so with that, anyone not okay with it? All right, so now, Mr. Baker has what he needs to bring a draft ordinance back to the council.
I've missed 2 on my list, Madam Mayor.
I can breathe, just give me a breath, okay? We then have to go back, and Mr. Newton raised the question of having all protected classes in the 15 and over employment discrimination. So we've talked about this a lot, so if you're in favor of all the protected classes being in the 15 and above beyond the Crown, please raise your hand. 1, 2, 3, 4, 5, 6. Did I get 6? All right. Newton, Graham, Johnson, Isolt, Eggleston, Watlington, Bakari, and Newton. I know there were a few more that came up with that. All right, so that's that. The next item is city contractors. The next item comes from Mr. Bakari.
So on that point, and I think Mr. Bakari is referring to Section 2167, contractor bid requirements. That is not language that has been changed. That is language that has been in existence since 2002. The only changes would either appear underlined or strike-throughs. And what we try to do is in any section that had a change, we showed you the entire section and the changes. So the areas, and I think the first sentence about shall include a certification to be completed by the bidder, that's the original language in the ordinance. We have not touched that.
I recall when that was done, there were some issues that
And I believe that's
generated
how
that
it's
need.
been used
Yes.
the entirety of the ordinance.
All right, Mr. Phipps?
Yeah, as a part of the bid solicitation process, does the city request a copy of the bidder's non-discrimination policy? Or they just ask for an attestation?
Ms. James, this is not something that I've been, I've only been focused on the revisions and not the.
I don't believe we require that, but I think we have this language that's in the ordinance incorporated into all contracts. So this exact language is included into contracts, typically. And by signing it, they're certifying that they will abide by the terms of the ordinance.
So I do believe they do some testing of it, though, Mr. Phipps. I do think that they do kind of like a regular kind of check, did everybody do everything right, but not every contract. Does that make sense? They sample it.
But they don't ask for a copy of the actual bidders.
Can't hear Mr. Phipps.
But we don't ask to see a copy of their non-discrimination policy, right?
I can't answer that, but I know that they sample and they check whether or not they have followed through on these items in a sample group. That's the only thing I recall.
And that's information we can follow up with
up.
before Thursday.
Okay, so that's
Madam
on.
Mayor, if I may add one thing to what Mr. Phipps had asked earlier on the disqualification, the answer to that, which is already in the ordinance, is disqualification up to 2 years. It's not in what's before you because it's in a different section. It's been on the book since 2003.
Okay, the next one I think we've addressed is the employment over 15. Is there anything else to add there? And then the last thing that I have listed is the religious protection, and we have agreement on that.
Mr. Bakari and I will be working on that together.
Yes.
Yes. All right.
I have my item. Are you coming to that, or is it already done?
We just talked about the city contract, and we haven't taken an action on it yet. So it has been included since 2003. Is there a direction to take that out? Please raise your hand.
I would just like to, it's obviously more complicated given that it has existed before and now we're adding to it. I think your takeaway is to get us some more information on, because we would not just be tweaking something and not including it. We'd be changing something that's been in there for a long time.
Right.
And I'm just concerned about the burden, particularly on small businesses. clearly the spirit is we don't want people we do business with to discriminate. I'm 100% on board with that. But then how we implement and weave that into the bureaucracy does concern me greatly, because we are trying to get people to be, especially small businesses, to be able to work with us and get contracts. And if they have to come through, it can be a very difficult, daunting task to say, yeah, I'm a 7-person mom and pop shop that doesn't have 700 different policies in place. Like, am I non-compliant, right?
And what I'd like to do is bring some information back from the administration to you about that, because the only reason that 2167 is even in front of you is because we dropped in a new protected class in that, not because of the questions that you raised.
I'll hold back from any judgment on that, but my hope would be not just to bring something back, but in the time we have, is there some way where the spirit of preventing discrimination from a reactive perspective can be put in there, but not have to weave in proactive bureaucracy on top of small businesses that may not very well be in a position to produce the documentation that this would require in testing or whatever it may be?
Sure.
All right, so you'll get information about that, but is there any additional request from the council about the information? You know, I think one of the things that I would say is how many contracts are really small business that we include this in, because I don't think that most of our contracts that fall under $500,000 are, and I think the level of it, it's probably for those larger contracts and not for just small businesses. But let's find out who does it and why and how. I think it's who does it and how do they do it. Mr. Graham?
And how do we define small business?
Yeah, defining
which is
it.
really important, because a small business can be a company with 1,000 or more employees, right? I mean, if you go by the Commerce Department definition of it, right? So I think we need to be careful about the word choice and how it impacts individuals and companies, because we could be protecting someone that does not need protection.
Okay. Thank you. We've got the notes there. I do not expect that will be as easy to get by Thursday. Is that a fair statement or assessment? I just want to make sure.
Yeah, that's beyond the purview of the city
Yeah.
attorney's office. This is really squarely within the administration's perspective.
So, Mayor, what we'll do is gather information for the council to see if there is a problem that exists.
Okay, so we'll look and see if anybody has ever objected to it first, and then go and find out what the information is, because we can always adjust that. All right, Mr. Eggleston?
I didn't have a question.
Okay, thank you. All right, Mr. Bakari, after city contracts and small businesses, what was your next one?
It's inserting as a protected class political affiliation and expression.
All right. Do you want to make any comment about that?
So, I mean, yeah, based on what I
Any
said
further
before,
comment?
the places, just so we know specifically where it goes, Article 3, Section 1258, prohibitive acts, just adding in Section A there, political affiliation, B, political affiliation in there with the rest of the items, and then Article 4, Section 1283, prohibited discriminations in employment, adding that as there as well.
How do you define political?
Your registered
discrimination?
Affiliation in the state board and
Is it by
Mecklenburg
official
Board of
parties
Elections.
like Green Party and everybody? Or how do you define it?
Yeah, it's how you're signed up formally inside the Board of Election website, affiliation, and then expression is defined as a legal action of expressing that affiliation. So if it's a
Okay.
march or walking into a coffee shop with a Republican shirt on or whatever it is, the whole premise is we should be opposed to all forms of discrimination.
Would it include Planned Parenthood and organizations like that?
I don't believe that's a political affiliation.
I mean, it's a point of view. I was just asking. I really don't know the answer to it. I'm just
Political affiliation
asking.
is a very specific word of like our party system in the country.
So would the party system include those areas that
If you are
have-
marching for or
I'm
against
sorry.
Planned Parenthood, yes, being fired because your employer saw you lawfully doing that and having disagreed with it, that would be a form of discrimination, yes.
Okay. All right. So you've heard the definition and the request for that protection. Those in favor of it, please raise your hand. Mr. Bakari. Thank you. All right. So with that, Mr. Baker, do you have everything that you need?
I think so. We can get,
Mr. Newton, you had 3 things.
I had one more thing that I think was potentially could be covered, on 2 grounds here. So 2 things maybe that we can resolve at one time, and that's the fines. I had mentioned earlier whether or not to include fines alongside the injunctive relief and conciliatory relief. So I recall during our conversation that seemed somewhat confusing, a bit kind of convoluted there, but I think that Julie might have mentioned, maybe you, Patrick, kind of preparing some language for us to review for that, but I don't know if that's what we concluded, and frankly, it's not something that the city attorney said that he needed, but I do think I would like to have some clarification on exactly how we're going to consider and broach that.
and I thought we would bring back to you by Thursday what the ordinance, how that's set up in terms of fine structure. It's baked into the ordinance. That's not been a point of focus, but we can certainly have that information so you at least know what's potentially there, and then you can make any decisions.
Would you be able to draft proposed language associated with that too? Because I think that was the previous request, was kind of seeing how that would look in writing for us to consider on Thursday, and then potentially, if it's something that we would like to proceed with, potentially could serve as an amendment proposed on Monday night.
Yeah, we can have that information for you, absolutely.
Great, thank you.
Mr. Phipps?
I'm trying to figure out, at what point would fines be levied? Would they be levied after the case has been adjudicated and determined? I mean, could it be conceivable that the court would levy any kind of fines and then we would levy fines on top of that?
That will be part of the information that I bring back to you. I just don't know it right off the top of my head in terms of when fines would accrue. I would assume there would have to be some level of determination that wrongful conduct has occurred and is not being remedied, but I will have more information about when that could accrue.
I think we're doing a lot of things that we need to get a track record on, and so I understand the need for fines if we're not getting compliance, but we don't know what we have and what we don't, and I just am very concerned that we have introduced a number of factors into this that are very, very acceptable to a lot of people. And then to have people walk away, I think Ms. Eisel said at the beginning, to do something so good and have people walk away feeling so harmed is not where I think this council could or want to be. And so to me, I think having the language is fine, but I would say to you that my suggestion would be to get some data like we do on our other areas, how often, what's going on, where is it working, if it's not, before we begin to talk about changing some of our processes in terms of injunctions and fines and things that really bring this to, if it's the first one out and we all say that that's it, but what if it's only 1 out of 100? I mean, there's a certain amount of thoughtfulness there. And Mr. Newton, I agree with you. You need to have it. It needs to work. But I also don't know that we could say that it's not working. And until we have a definition, that would be my position. Okay? All right. Is there anything else to come before the group? All right. Do I have a motion to adjourn?
Second.
Second. All in favor? Aye. Thank you.